First.
ಕರೆಕ್ಟ್ ಆಗಿತ್ತ ಅದು ಕರೆಕ್ಟ್ ಆಗಿರಲಿಲ್ಲ.
ಇಲ್ಲ ನಾವು ಎಲ್ಲಾನು ಒಟ್ಟಿಗೆ ಕನೆಕ್ಟ್ ಮಾಡಿ ಅಂದ್ರು. ನಾನು ಅದನ್ನ ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ಟೆ. ಮಂಜುಳಾ ನೋಡ್ಕೊಂಡು ಹಂಗೆ ಆಗೋದು. ನಾನು ಅವಾಗ ರಜೆ ಇದ್ದೆ. ಏನು ಮಾಡು.
Sorry, Lordship. Not a question for hearing, but for the fact that the bank. And I'm proposing very short issue, not the Lordship. For the other issue. That's why. Also, this is one thing factor that one important initiative is very proceeding. Commercial tax. Is that maybe this one? Getting check completed. You can relax. So use the one alone. That's a little bit. What is not working? That's the model is trying to.
This one?
Yes. I just consider our dependence.
Very difficult to have a lawyer.
And actually, I'm British history. My mother is British history. My father is a lawyer as an but he's 70 years, so he's unable to.
If you have a lawyer.
He will argue more, but why we see him.
Yes, taken permission.
Yes, yes, ma'am.
Amendment, this one, page number 1, serial number 2 to 9, page number 2, 10 to 20, page number 3, 21 to 30, 23.
It is informed. Informed them. Something what. No, but the code is informed as well. If the lawyers are frequently attending, then you can.
Page number 4, 31 to 33. Page number 5, 34 to 43. Page number 6, 44 to 54. Serial number 1, Arjun. Number 2, Ravi Raghavan.
Speaker on. Yes. Yes. No, correct. You say in connected matter 1014081. There's an interim order. The same issue. Same SSC. Where is that interim order? BST G1. We'll pass over, you just wait. You just show it to him. Show this. There's no prayer. Learned counsel. Madhanan Pillai is directed to accept notice for the first respondent. Learned counsel G1 is directed to accept notice for respondent 2N. Yes. Commercial taxes. Learned counsel Hemkumar Kumar accepts notice for respondent 1 to 3. They have said that it's an ex parte order. Let's take notice. Counsel Hemkumar Kumar accepts notice for the respondents. Any interim order you have sought?
Subsequent period also I am filing similar.
Let us see. We'll find out.
Subsequent period, there is an extra ideas depend on that. I think this order they will not give to the
Let us list the matter week after next.
Serial number 4.
Pass over. In 4. What is the case? 148 AB. Correct. Have you read the file, madam? You should read the file, isn't it? When you're coming, you must say, the judge is a strict judge. He will not permit adjournment unless you know. No, is this the case where time granted was only 5 days to reply. Ah, we will issue notice. Let them take. Income tax. Learned Council Sanmati accepts notice for the respondent. Some violation of principles of natural justice. You have a look at it. We'll have it next. I think only 5 days notice was given. Just check it. Relist the matter next week in preliminary hearing list. If that is the only point, then we can. Yes. The draft assessment order was not passed. Yes, income tax. Learned Council Sanmati accepts notice for respondent 1 to 3. One of the stands taken is draft assessment orders not passed and violation of 144C procedure. That is the main point. On merits, we'll see. What I'm saying that if it is so that 144C procedure is not followed, we'll send it. Release the matter next week in preliminary hearing list. Passover. This is the same service tax. Yes. The same interim order as in other matter. Joint Commissioner of Central Tax. Correct. So the same interim order will come. You have that in the corrected matter. Oh. Huh? Triple 154 of. No, correct. We'll be tense till the end. Interim order. The counsel for the petitioner submits that the legal issue raised has been raised in other matters as well, including WP 8514 of 2023, in which interim order has been passed, which reads as follows. In light of the submission made, petitioner would be entitled to an interim order on same grounds as noticed above. Accordingly, there would be stay of Annexure A. List the matter along with so and so. This are the 230 listed. Respondents are liberty to file the statement of the respondents to file the statement of objection and liberty to seek for modification of the interim order if circumstances are so made out on filing such statement of objection. Yes.
Law into a officer because it is based upon a reassessment pursuant to a search in which no incriminating material was found. And these are unabated assessments.
Can't hear you. Why are you so soft? Assistant Commissioner of Commercial Taxes. 1 and 2. Two state of Karnataka. No, he has amended. You must give the final copy, isn't it, to the.
But these are very old.
Is directed to accept notice or respond 1 and 2. Central Board of Indirect Taxes. Council G1 is directed to accept notice to the as regards the third respondent. Let us see. Let them take instructions.
And when it's a convenient date for you.
8, 1.
Until the July is not convenient, we have only in the month of August. We can post it on 21st of August.
Page.
Meanwhile, you file your written submission on this legal point.
Page.
So that they
The final order is. Tara? Yes. Learned counsel for the petitioner. Correct. I see. The learned counsel for the petitioner submits that the delayed availment of ITC has been considered in a detailed interim order passed in WP number of 2020. Taking note of the after having perused the said order, petitioner is entitled for an interim order on ground of parity. Accordingly, subject to further consideration, there would be stay of the impugned order in annexure B and C, and the petitioner, however, is required to maintain a minimum of 10% of the disputed availment in its electronic credit ledger, subject to further orders. Not before me. Not before me. The stay not before me. Can the challenging. But now you have participated in the entirety of the proceeding. Assessment order. Expert here.
The assessment of the past is not contained again. Primary condition of 148 itself.
Let us see. We accept notice. And Council Sushant Tiwari accepts notice for the respondents. List the matter in the orders list on 13. On 19. Consideration of interim players kept. Yes, same, yes. And AGA is directed to accept notice for respondent 2 and 3. And Council Madan Pillai is directed to accept notice for the first 2 to 4. Madan Pillai for the first respondent. Petitioner submits that now what is the difference between this and that other matter? The counsel for the petitioner submits that this is also delayed claim of ITC. That the question of delayed claim of ITC is a matter of adjudication in other petitions, including in WP 10704 of 2023. In the said petition, the court, referring to the interim order passed in WP 3997 of 2022, has ordered as below. Next. Accordingly, after having perused the interim order passed by the coordinate bench, in the present petition also, there would be an interim order of stay of annexure E and F, subject to petitioner depositing 10% of the tax amount. So same as in the previous matter. Accordingly, there would be a stay of order annexure E and F, subject to same direction. Maintenance of 10%. Yes. 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 ಇದು ಆನ್ಲೈನ್ ಮ್ಯಾಥ್. ಸರ್ವಿಸ್. Yes. Will you appear?
So, waiting for the direction of the DRP. Assistant officer asked the before DRP is direction. Exception clause is invalid, right? Declaration error. This connection in is honorable for finance.
Page.
Correct.
Yes, what do you next week? Only on this point we'll dispose it. Release the matter in the same stage next week. I think I had also passed an order on similar line. Just check.
Order and correction.
No, I also passed on similar lines. If you find, you check. Then we'll dispose it off on that and send it. Come yes, next week. You have extra copy. Now, what is the point? Let him take instruction. What is the point? Yes. Yes.
Order was not also the direction of the honorable court. Here, again, as they are yes, they are the citizen of the honorable court. They are shared and direct member. It's not distributed in all the program and this is for the assessment year 17-18 megawatts. The year in which the land development has been that is liable for category. Here no construction is happened, even not even approval has been taken for the construction of building there method. This is by honorable issue in the case of the case of not acceptable because here is handing over the land does not amount to partition price not yet attracted. Here giving a
What do you
position to
what do you say? Didi?
What is that going on?
Correct. Now he's saying on merits. Correct. He's saying on merits. The position of law is clear by virtue of the judgment of the Supreme Court in case of JDA. If that is so, must you not take that into account while exercising the discretion? Next week. We relist the matter in the orders listed on Learned Counsel Sri Dilip accepts notice for the respondent. Just look into it in the next week.
14.
Yes. Land Council Sanmati accepts notice for the respondents. Yes.
16, 17, or was passed at a time. The words of in that most of the issues that have been raised are covered in 9 what remains is not covered in the covered issues. Take that one. Later assessment or mitigations made for 17, 18, 18, 19, and 21, 20. Determining refunds of 1,400 crores. I find an application. Made the one was passed. Which not should get. Connection AA, which P57. Volume 1.
Yes.
Because it's here. Parrot. In state, they have noted that what is the demand for the year in the paragraph. Paragraph is the state division, the SC has published the demand handling each of the issues on which additional disallowance have been made. SC is relying on all this office memorandum, CBDP dated to regulate office memorandum, CBDP dated, wherein the CBDP has mandated that the payment of balance mandates the AO shall refer to matter PCI for necessary direction.
Now you pay 20%.
I have paid the 20%, which I will that some 50 crores I paid. I show that later on. Considering all that, I see paragraph 3. In this regard, the reference was made in the commission and after considering the details, as directed to track the state of demand from collection of further demand. In view of the above, as a petition for stay is granted for further collection of demand, stay can be granted 20 GB. Thereafter, stay has not been extended. Now they are seeking to against 1,400 crores refunds of the other assessment years against this demand.
Why
My
stay?
main prayer in the
Why stay has not been extended?
If you not kindly see page 359, my application for access from stay as the 26. They want to adjust the 1,400 quotes against this demand. I am seeking my main prayer in this situation is for refund of those amounts because as per the CBDT circular, I have paid the 20% and in view of that, they have granted me a stay for 1670. They cannot adjust around those refunds because otherwise, year after year, the appeals are my appeal for 1670 is 20% average for very long time. That appeal is not being disposed of. My working capital amount is stuck to the department. Let's say the funds form on 1,400 is stuck to the department. And they very clearly agree that most of the issues are covered in my favor by apparent authorities in my own case. continuous stay of on payment of 150 crores. My payment of 150 crores which your lordship wanted to see. You can pay 133.
No. What is the relief you are seeking now?
My main prayer is for refunds which are already determined for 17, 18, 18, 19, and 24, which is about 1,200 crores. Interim prayer I am seeking not final prayer also, interim prayer also. What I am seeking is pay this 1,600 crores after deducting. Out of 1,700 crores, I have paid 150 crores, but remains is 1,600 crores. Please stay so that they don't make any further adjustments on my payments.
That is the subject matter of the pending appeal. We'll have it on next Wednesday, but suppose there's an order of stay. Why it has not been? Why it has not been passed? No, correct. What we are saying, once you grant a stay, and he has fulfilled the condition of you say 20%, there ends it. You can't review it. Orally instruct them not to do any no adjustment till the next day. And we list the matter in the orders list. On Council Sanmati accepts notice of the respondents. Just because he's a big entity doesn't mean you can.
They more than what our liability is, no other demand is there. But every year we have a case of payment as per our return. Even this 17, 18, 19, your orders, and seeing the return as per my return itself, the payment is easily 500 crores. Okay. If I pay more, so that these issues I can avoid. But all these reports are adjusted against demands and all the issues are covered in my most of the issues. What remains is some issues we have to prepare.
Any of that?
I'm paying the 20%.
Any of that is a matter in appeal.
Yes.
But there is no warrant for not extending the interest. Yes. On 19. How did you? Income tax. Land Council Sanmati accepts notice of the respondent. And another thing, what I feel, just an observation. If there are bona fide taxpayers who have generally been compliant, you have to accommodate little more. Just to see that those who have always been on the right side, they should also feel that now before, when we were lawyers, they used to give some certificate. If you pay some income tax, that's still there and stopped. Earlier, used to give some certificate, some silver, gold, something like that, isn't it? Huh? That continues. I'm saying, little, in case they're good, in case they're good, SSCs always been on the right side, little you must be accommodated. So that their faith also is very, yes. Yes.
Stay applications. See. Stay application. Within 2 weeks. When application was filed, from 2 weeks at last, nothing has happened. Suddenly, when I was in April, this March, this is an issue. Other banks are taxed at the very beginning. But certainly, no doubt that it's supposed to pay 20%.
And the circle also easily and feel by the water. Right level versus still out. I use the 20% is unknown. It doesn't dispose of my application. And straight away after cover it. Circular is a different group. Feature is one. After we 20%, it's just still also demand. Because giving it not.
We'll have it next week. Learned Council submit accepts notice for the respondents. List the matter in the orders list. Next. Delist the matter at request. 2 weeks datehood. Yes, Jeevan. What is the instruction? No, now they're saying by next week they'll sort it out.
No continuation of after that, 19 amount, they are not and they have raised the amount without any notice and without what to restart my business without the bank account. I have income. I'm undertaking to make personal part also I protect it.
Correct.
I not accepted their sleep there. They are offered me members. Income because is my lord.
No, but whether notice was issued prior to freezing of account.
Oh. And immediately unexpectedly, there my lord. They have stated, they themselves stated there that I have made a payment after receiving the notice. Unexpectedly, my lord paid him 26. What they are claiming that my lord asked for is all of number 2. They might be seen as 13. The observation of letters and the government communication is because it is concerned that after initiation of investigation, the department has a payment of service that around 85 and 98,000. However, there is difference in the attribute value declared to the department and also the income shown as per balance sheet. There is a difference of 30% accordingly, the difference of service tax amount is covered. So like 8 lakhs, 4 lakhs, 10 lakhs. Total 19 lakhs I have paid.
You have paid? How much you have paid?
2018, I have paid 10 lakh 30%. Around 1 lakh, 829.
At page?
Page 29. Of that, this statement. That service that was tax payment, 10 lakh 30,092. And second one, 1 lakh 2,052. And 8 lakh 42,818. Subsequent to this, my lord. Some more the communication was done on annexure. Or what is the annexure payment?
Now, this was in response to their earlier. In that, what was the amount due according to them?
According to 16 lakhs. 15 lakhs, 15 lakhs. The different value. One after that, my lord, in response to the annexure key, that page was 43. I have taken an annexure key, my lord. Page number 592 after the subject and reference system and all the payment is service that. That series will not be lesser than 1.80. One after that, I have made a payment of 10 lakhs. So, as per their my lord, I have paid 36 lakhs, my lord. Because some interest was on that period. I have also paid that one.
No, but once investigation is pending, without ascertainment of tax, how you can attack? Now, investigation is pending. Earlier notice you gave.
Someone notice. It's
No, correct. That is when investigation is pending and he's paying, he's making payments. Then on what basis you attach his account? So to the first notice he has paid whatever you have raised. You go to annexure, page 26. Annexure D. In terms, annexure D has been complied. Then subsequent notice has been issued. Yes. Yes.
tax and applicable interest. We model of the grant
16 lakhs, 23,907. Short payment. So that he has paid in terms of annexure D.
That also may not annexure E to our
Annexure?
15 lakhs of the
first notice 23/1/2018 they have issued. That also I made it break already. Relevant payment, another statement. Before February, I made a payment 10 lakhs, 10 lakhs, 11 lakhs, 10 lakhs, 11 lakhs, 10 lakhs. That's clear to that. After that, they have accepted 23, one more notice, this is not payment of 6 lakhs. For that also, I need to get one I have produced. But after because they have informed that if you pay more less than 50 lakhs, required to pay only 30% of the arrears in addition to that. The India that in 1945, definitely you are
No, but now investigation is pending. It is yet to be ascertained. Is before you. May not be proper to continue the attachment for such a long time. Let him now. Let him give his undertaking. He'll cooperate. We'll keep the matter pending after, so that he participates and cooperates with the reconciliation process. He'll be. It's the matter on Friday. Yes. Tomorrow. Yes, Sanmati. To take us through the relevant facts. That notice was issued in whose favor? Now, notice is issued in the name of Wipro Infra. Engineering Limited. This is for the assessment year. Now, this is a existing concern or? This amalgamated is Wipro Limited. One four. First April 2007. So Wipro Infrastructure Engineering Limited came to be amalgamated with Wipro Limited. So, Wipro Limited also has undergone a change. Wipro Limited was custodial. This is as per which order? So this is a separate proceeding. Annexure. Page.
Lords are taking item 20, my lords.
18.
Obliged.
Page? Where do you get the reference to the names of these companies in the order? Or you just point out somewhere in the one? Yes. Now, in terms of this order passed in COP 8 of 2013, what was the resultant effect?
Continuing business under the name.
No. Kind of merger. No. Change to yes. My God. I don't know what. Okay, yeah. Yes. 2007. Yes.
There are actually something very number one.
Yes.
Some transactions.
Came to be subsumed. I mean, came to stop functioning in 2007 itself. Yes. Pointing out this. Yes. Page. Yes. So now if the proceedings have to continue, yes, okay, any clarification is required or we can dispose it. It's on 5/8/2008 itself. With Wipro Limited. So they were aware. It should suffice. We have already brought to their notice that it was merged along with Wipro. Now the subject matter of transactions leading to the issuance of notice is as regards which entity? Now they're seeking to reopen the assessment proceedings under 148 as regards which entity? So then we'll dispose it. Shall we dispose it? That last paragraph. We have said as is permissible and as per law. Yes. Now you have mentioned all these developments in your synopsis. Or? The yes. The petition has been filed. Seeking for setting aside of the order dated 31/3/23 at annexure A, passed under 148 capital A small d of the Income Tax Act, comma, setting aside of the impugned notice under 148 as well. It is the contention of learned counsel so and so appearing on behalf of the petitioner that the notice under 148 AB and the order passed under 148 AD and subsequent notice under 148 issued in the name of the petitioner, issued in the name of issued in the name of Wipro Infrastructure Engineering Limited. It deserves to be set aside in light of the scheme of merger and demerger sanctioned by the company code. Sanctioned by the High Court. Third counsel appearing for the petitioner submits that Wipro Infrastructure Engineering Limited came to be amalgamated with Wipro Enterprises Private Limited. Came to be amalgamated with Wipro Limited with the appointed date of 1/4/2007. And accordingly it is submitted that Wipro Infrastructure Engineering Limited ceased to have any legal recognition from 1/4/2007 onwards. Attention is drawn to the sanction of the scheme of amalgamation at annexure D. Accordingly, it is submitted that in terms of the judgment of the Apex Court in Principal Commissioner of Income Tax, New Delhi versus Maruti Suzuki India Limited, the notice and assessment notice and assessment proceedings in the name of non-existing company would amount to a substantive illegality. An order passed against such non-existing entities without jurisdiction. Reliance is also placed on the judgment order of this court in Coffee Day Resorts Private Limited in WP 9594 of 2023. Next. Heard both sides. It must be noticed that the order under 148 capital A small d at annexure E has been passed in the name of Wipro Infrastructure Engineering Limited. And a reading of the said notice would indicate that the subject matter of the notice relates to transactions of Messrs. Wipro Infrastructure Engineering Limited, which has since amalgamated with the Messrs. Wipro Limited. The said fact has been noticed in para 1 of the order at annexure A, which reads as follows. Next. On this sole ground itself, taking note of the law laid down by the Apex Court in Principal Commissioner of Income Tax, New Delhi versus Maruti Suzuki India Limited, 2019, 107, taxman.com, 375. The proceedings at Annexure A, which is an order under 148, capital A D, and the subsequent notice under 148 at Annexure B is liable to be set aside as proceedings instituted against a non-existing company in light of the order of amalgamation as noticed above and also noticed at para 1 of Annexure A. Next. Accordingly, the 148 capital A B small d order at Annexure A and the 148 notice at Annexure B issued in the name of Wipro Infrastructure Engineering Limited are liable to be set aside. Needless to state, authorities are at liberty to initiate appropriate proceedings as is open in law and permissible insofar as contents of the notice under section 148 capital AB as against the appropriate entity in accordance with law. All contentions of both sides are kept open. Yes. Yes. Now, what is the Wipro Limited is the where do you get it? Now, this entity, Aperio India Cloud Solutions, was merged with Wipro Limited. As this take me to that relevant paragraph. Now, by virtue of this scheme of arrangement, Aprio came to be merged with Wipro Limited with effect from 1/4/2018. Yes. Yes. Yes.
Page 81.
That is dated. Now, this letter at annexure H relates to the assessment of Wipro Limited. 148 AB notice at annexure. So they issued notice in the name of the. It's called as a transferor company. Yes. Now you have brought it. Yes. Then what happened? One. Now 148 AB is annexure A. K. So in the reply you have pointed out. Yes. Yes. No, now yes, that I've seen. Now 148 AD. The order is past name of Aprio. Yes. The petitioner Wipro Limited has sought for setting aside of the order under 148 capital A small d of Income Tax Act for the assessment year 1920 at annexure A, and has also sought for setting aside of the 148 notice at annexure B. There is a contention of the learned counsel appearing to the petitioner Sri Sandeep Ligo that the notice under 148 capital A small b at annexure K has been issued in the name of Appirio India Cloud Solutions Private Limited, and this is followed with an order under 148 capital AD at annexure A passed in the name of Messrs. Appirio India Cloud Solutions Private Limited as regards the assessment year 1920, while the said entity has merged with Wipro Limited, the petitioner herein, as per the scheme of arrangement sanctioned by the NCLT, with the appointed date being 1/4/2018. Accordingly, it is submitted that no notice under 148 capital A small b could have been issued, followed by an order under 148 capital A small d in the name of Appirio India Cloud Solutions Private Limited, which was a non-existing entity from 1/4/2018 onwards. Reliance is placed under judgment in Coffee Day Resorts in WP so-and-so and Principal Commissioner of Income Tax, New Delhi versus Maruti Suzuki India Limited. To contend that notice and assessment order passed in the name of non-existing companies is substantive illegality and order passed is one without jurisdiction. And counsel for the petitioner also submits that in the reply at annexure L2 to the notice under 148 capital A small b, this aspect of merger of Apperio India Cloud Solutions Private Limited with Wipro Limited was brought to the notice of the entity, which has also been referred in paragraph 1 of the order under 148 capital A small d. Next. Taking note of the law laid down by the Apex Court in Principal Commissioner of Income Tax versus Maruti Suzuki, referred to Supra, legal position is settled that notice and order passed against a non-existing entity amounts to a substantive illegality. Clearly, in response to the notice under 148 capital A small b, the reply at annexure L2 brings this aspect to the notice of the entity. Further, at a prior point of time, the intimation was made to the Assistant Commissioner of Income Tax on 29/3/22 at annexure H regarding Apperio India Cloud Solutions Private Limited having merged with Wipro Limited. In light of the undisputed facts relating to merger of Apperio India Cloud Solutions Private Limited with Wipro Limited, question of issuing any notice after 1/4/2018 in the name of Apperio India Cloud Solutions Private Limited would not arise. Accordingly, on the sole ground itself, the order at annexure A and the notice under 148 at annexure B are set aside. Para 9 repeatment. All contentions of the petitioner are kept open.
Now, 20.
May I please, my lords? My lords, on the last occasion, my lords, this case was taken up, my lords. What happened in this case? This is the second round of litigation, my lords. Originally, my lords, there was notification which provided that on the freight element which the foreign party bears, the Indian party has to pay.
Just one.
Yes.
Learned counsel Sri Madan Pillai accepts notice for the first respondent. Yeah. Yes, Jeevan. I'll pass it over, let him come.
All right.
Pass over.
Obliged.
Jeevan. 20.
Yes, my lords.
So what is this matter?
Yes, my lords. My lords, in this case, my lords, a notification under which we paid a tax, we paid tax and then challenged that before this honorable court. In the first round, my lords, on the basis of Supreme Court's order quashing those notifications, this honorable court, my lords, allowed our petitions also and directed the respondents to grant refund to us. Now, my lord, what happened was that whatever tax we paid at that time, which we claimed as refund, My lords, after our payment of tax, my lords may just note 2 dates. My lords, the concerned period in this case is September 2017 to October 2019. We continued paying tax on the freight on, my lords, the goods which were consigned from outside India to India. The Supreme Court said that since the freight element is already included in GST paid on the goods, therefore you can't again levy tax on the freight by treating it as service also. There can be no double taxation and you can't treat the same thing as goods and service both. On this reasoning, my lords, the Honorable Apex Court quashed those notifications. Now, my lord, prior to the quashing of those notifications, law came to be changed in 2019. My lord, what happened was that when I have paid this IGST, which at that time was as per the notifications, that IGST, my lord, had to be taken as credit. It was my input. There is no difficulty about it. But I never utilized it because I was arguing before the Honorable Court that it is bad in law. And I intended to claim a refund. In the meanwhile, my lord, a provision came which said that whatever IGST would be there in your ledger, we will automatically use it up. So, my lords, what happened? Even though we had sufficient balance of IGST, CGST and SGST, automatically, my lords, entire CGST, SGST, everything started to be paid only by using IGST, even that amount which I was claiming before this Honorable Court as refund. Meaning thereby, my lord, CGST and SGST kept on increasing and IGST kept on reducing. I wrote to the departmental authorities, look, this is your system. I don't intend to use it like that. What is happening is, in this case, IGST is coming down and getting converted into CGST and SGST. So tomorrow, if I win a case before the court, I will claim refund of CGST and SGST because IGST is automatically getting reduced. They, my lord, stayed mum on that letter that I filed. When, my lords, I filed refund application consequent to my lord's order, my lord, thereafter what they say is that at that time you should have debited that IGST and that you have utilized it fully. On this aspect, my lords, Gujarat High Court, my lord, has taken a view which squarely covers this issue. The Gujarat High Court says that this is a case where it is being automatically converted from IGST to CGST and SGST. Since we have quashed the notification, this amount needs to be restored to the buyer. That, my lords, would have, my lord, it is by the name Radhesham Spinning Private Limited. My colleague, my lords, Mr. Allur is there. My lords, para 3, my lords, would see. However, the controversy does not come to an end over here. After the present writ application was filed on 18 December 2020, Section 49 of the CGST came to be amended with effect from 1/2/19, and new Section 49A and 49B were inserted in the said Act. By virtue of power under Section 49B, Rule 88 was inserted with effect from 29/3/19 in the CGST rules, wide notification number so and so. In such circumstances, with effect from 1/2/19, the ITC available on account of IGST has to be first utilized for payment of GST or CGST or SGST. This provision was amended with effect from 1/2/19, but the portal started functioning as per the amended provisions with effect from 1/6/19. Therefore, with effect from 1/6/19, the accumulated ITC of IGST of rupees 3.37 crores, additional custom duty paid by writ applicant, started getting utilized automatically during the pendency of the petition. In view of above, the ITC of CGST and SGST started accumulating correspondingly. In such circumstances, as on date on account of such amendment in operation, the writ applicant have nil balance of IGST in its electronic credit ledger, and IGST balance is converted into CGST and SGST. In other words, the balance of CGST and SGST got artificially inflated as a result of appropriation of IGST credit. In such circumstances, after referred above, this writ application is allowed. The respondents are directed to sanction and pay the refund of 3.37 crore after first reversing the entries of utilization of subject credit and debiting the said amount from credit ledger consequently available to writ applicant. This is the only issue, my lord, that in my case, my lord, what the authority is saying, my lord, let me first show that how it changed the face. There is a CA certificate, my lord, which we have attached before this honorable court, my lords, who has given the ledger and has, my lords, how this has changed the shape, my lord would see. Annexure K at page 153, it starts. I would first like to show to my lords how this ITC, my lords, have changed the shape from IGST to CGST. CGST and SGST kept on increasing, IGST kept on dwindling. Page 158 is that ledger, my lords, which the CA has given along with the certificate. This is from the portal, my lords, their own portal, the respondent's portal.
Yes.
Yes, my lords would see these entries. My lords would see on 20th of November 2019, the integrated tax balance was 13.89 crores. And the central tax and state tax was 3.68 and 3.68 crores.
Yes.
Therefore, my total balance, my lord, far excess from the refund that I am claiming. 3.74 crore is the only amount that I am claiming. I had far in excess. Then, my lords, what happened? Because of this automatic provision, my lords, 27/11/19, my lords would see, I got a credit of 51 lakh that got added. Now, my lords would see the entry at serial number 6. 19/12/19. My lord, this is November 19. There is a debit. Means I have to pay the duty, 6.82 crores. And my lords would see that this 6.82 crores is entirely utilized from IGST because of the new provision. And my lords, the CGST and SGST remains as it is. This is by the portal itself. I can't do anything. Then, my lords, the next debit is serial number 9. So, my lords, if at, my lords, this very date of 6/19/12/19, my lords, after utilization of 6 crore 82 lakh, the balance in the IGST ledger is 12.33 crore, which has started to reduce. Whereas, my lords would notice that the balance in CGST and SGST has started increasing, 4.75 crore and 4.75 crore. And this trend, my lords would see all through up till, my lords, June. My lords would continue to see this keep on increasing SGST and CGST. This is what the Honorable Gujarat High Court says. IGST is reducing automatically. CGST and SGST, it is taking shape and form in the nature of SGST and CGST. This, my lords, is the precise letter that we wrote to them. My lords, that letter, my lords, would find at annexure. My lords, this is July 2020 letter, annexure F. Apprehending that this problem will come later on if I win before this honorable court, we wrote to them, clearly mentioning this fact. Page 66, my lords, would find it.
Yes.
My lords, I read, my lords, we refer to the writ petition filing that we have filed this writ petition challenging. Then, my lords, below that table, we say, as a consequence of new provision on order of ITC set off, IGST will be first set off against IGST, CGST and SGST payable. Due to the above rules in online portal while filing monthly GST return, IGST paid under protest, of which, my lords, I am claiming the refund, also got consumed to CGST and SGST liability. Under these circumstances, we are of the view that IGST paid on ocean freight paid under protest has taken the face as CGST, SGST carry forward pursuant to change in manner of set off of GST credit. In the event the High Court verdict came in the company favor, then the GST refund need to be processed from CGST, SGST carry forward amount. This is for your information and record. Now, my lords, so this is what, and my lords, they keep quiet. They don't say anything. They don't respond to, they don't deny to this letter. Now, my lords, if today, my lords, the Honorable Supreme Court and this Honorable Court has held that the original tax that was collected from me from 17 to 19, the period I have given precisely, if that has already, my lord, held to be ultra vires and bad in law, my lords, my submission is that it is no tax in the eyes of law. If it is not a tax in the eyes of law, my lords, I have to be restituted back to the original position, that is of the wrongful claim. If the portal today first collects the money, they collect illegally, retain it, and when it is held to be bad, because of their portal functioning today, they cannot take the stand that no, we will not give you the refund because you have utilized it. My lords, I never intended to utilize it, and therefore I informed to them at that very stage. So, my lord, my submission is that I am squarely covered by Gujarat High Court judgment, and what they are saying is entirely incorrect. And to further buttress my submission, my lords, the chartered accountant has given a certificate saying that I have examined this ledger. So, my lord, I ask myself a question. If assuming they would not have taken this amount of IGST illegally from me from 17 to 19, then also, my lords, I would have to pay my liabilities of output tax. So the chartered accountant has given a certificate saying, even if I remove that 3 crore 74 lakh, which you are claiming the refund from the ledger altogether, then also always you had enough balance of credit to prove your claim. That, my lords, I wish to show to my lords.
Yes,
My lords,
what you said. Just one minute. Yes,
Yes.
Jeevan, what you- just adjust your mic, just adjust your mic.
I cannot hear my friend, my lords.
Yes.
If my friend can speak in the mic, my lords.
Yes.
What he says is that entire IGST applies for the
No, but
not
correct. So his own,
what's IGST?
no,
IGST.
correct. But his what his submission is in terms of the letter made out to your department in at an earlier point of time. That is in July 2020, is it?
Yes, my lord, July 2020, my lords.
Yes, that my lord, the character of my lord,
No, so he has made it clear how he wants it to be treated. But he says, but because of how the system was working, it went on adjusting, and now he's saying that he wants a refund.
my lord, the section. He's my lord, just my lord, I'm unable to understand, my lord, how he says that my lord, artist character of CGC.
No, now he's saying if it is held to be illegal, insofar as tax between September 2017 to October 2019, there has to be restitution. The system does not, if the system does not permit and leads to adjustment in future, he's saying, give me the option of a refund. I don't want that adjustment to go on. I will do whatever liability separately. I will adhere to it.
As far as his motion practice. From that reason, my lord,
So his case, yes.
this on the court also has followed direct after the my lord, this on the direction is good order to pass. Declining to my lord grant a refund on my lord, the constitution there the order.
Now, what is the direction? Now, let us have a look at the direction.
My lords, the direction, my lords, would find that annexure, my lords, H at page 144.
Start 140.
Operative portion.
My lords, that is at page 144. The petition is hereby allowed and disposed of in terms of judgment of the Apex Court in case of Union of India versus Mohit Minerals. And, my lord, thereafter, second, respondents are hereby directed to consider the claim of the petitioner for refund of IGST amounts paid by petitioner in accordance with law, bearing in mind the aforesaid judgments and observations made in this order in accordance with law as expeditiously as possible and at any rate within a period of 3 months from the date of receipt of
So now you are saying that you are entitled to adjust it for future liability.
No, it doesn't system. The order doesn't system.
No. Now, what is your stand now?
That my lord, whatever the my lord, the tax, my lord, the paid, is that paid contest. I think implies for my lord discharge of an output tax liability.
But is he not entitled?
Entire implies that and my lord, the tax burden has already been shifted.
Has been shifted to?
This one, the customer of the. That's on that point, my lord, the authority rejects my lord. So again, my lord, granting a refund, we are unjust on the votes. Tax burden has already been shifted. My lord, that's what my lord order says. My lord,
And he says that a lot of CA certificate has been produced, that effect, so that there is no,
No, that you can verify from a CS certificate, you can verify whether it has been passed or not. You can verify. If it is not, then is he not entitled at his option to get refund?
Lords, in this case,
Just 1 minute, just 1
yes,
minute.
sir.
Page?
181.
Yes.
7.1. That. Before says, before proceeding further to discuss the reply of the CH, I would like to mention that the reply agreement had on more occasions mentioned that earlier ideas and products. In this regard, I find that as per the reports available, refund payment has not been consider all of these here in September, October 19, don't getting any progress. Third mind that near the end of the set period, they have letter stating that they are very like on the issue of payment of IDs on motion. Therefore, I hold that the payments of IDs made on motion refund payment cannot be considered as payment progress.
No, even otherwise, once the demand is set aside for the period of September 2017 to October 2019, now he will have to be restituted. How is that restitution now going to be done?
Restitution will be available, but amount which was paid under protest is there intact. But it has been utilized for the discharge of taxes, upward taxes, tax liabilities.
But doesn't it?
Becomes zero.
Okay, now is it not the choice of the SSC to claim refund or adjustment?
So now he has utilized it. That's what Malone is saying that I have not utilized it. It's automatic. But it partakes the character of Malone. I just get clarification from all these two aspects. This is only Malone. Narrow controversy is narrowed down to only this. Other Malone, the taxes which have been paid under protest have been utilized or not. And so it has become zero now. And output tax charge, as per the but I think consumer or
that is one issue.
That's one issue. That is other.
No, doesn't in other matters, will the SSC not have an option either to claim refund or adjustment?
That's an option.
We'll have it. Get instructions. We'll have it next week. Yes.
My lords, if convenient to my lords, can we have it, my lords? My lords may have it on 20th if convenient, my lords.
20th. Release the matter on 20th in the same stage. Now he's relying on the Gujarat.
I'm grateful, my lords. Deeply obliged.
You just make a small note on
Yes,
this
Lord.
adjustment, how it has done, your
Yes.
date of protest.
Yes, my lord.
And soon after the order of the court, how did they go? How was it adjusted?
Yes, my lord.
Choose an option.
I'll do that, my lords. That amount, my lords, they are slightly misunderstanding this issue, my lords. Actually, we have paid the entire amount and we have not adjusted. That I will show to my lords. That is what Gujarat says. That, of course, if you see only one ledger, IGST, you will see that it is utilized. But you have to see it in totality. It has CGST, SGST increases, IGST keeps on reducing. There is no question of utilization. I will show that to you. I am grateful.
Thanks. Yes, Arvind, what is this matter? Just simplify it. Yes. Annexure, page. Yes. For which year? Stay orders with respect to 17-18. This is for 16-17. Another notice. Annexure. The information in the annexure is different or same?
If they want to kind of. Forty-five by eight. Have been introduced. The tax. That is at the time, age 35 dollars fine. The developers deliver the owner. This one. And that is but the open other observe that all this is a pretty now. It doesn't. For both are okay. By land increase. That's the we want to apply 16.5 in bracket by me. We just come here from 1.8. As no about in that way. If they want to find out the sources, coming to the facts that it is a teacher. Your property. Each one had one girlfriend. And one property has been paid the 1780. Each year,
Now you have made out a reply to the one for. Annexure E, page 37. Now the sale deed, copy of the sale deed have you enclosed? No, the sale consideration has been divided amongst the three of them. That is, consideration is shown in the sale deed like. One third of. So one third of 54 lakhs 34,000. That is clear in the sale deed.
Something. Outside is not that, but still, we are being a of consistent number. These are like the amount of capital gain is payments. Equal up.
Sale deed was produced before the authority. No, any interim order is passed or no? Any interim order has been granted or no in this case?
If order is not been granted, just it's going on like that without being taken from your law. The mistake is fine. If order make identified, you're all fine. 149. Please.
Yes.
B or 190.
50 lakhs.
That's that. Yes. Of that 10 years, and that in the somehow other government leaders reveal that in the tax. The present reform of the system, which has stated almost like legal tax. So each year, this 67 has to be considered for. And everything it has to be considered for. Yes. These are some evidence amount for the sum and all.
No, just 1 minute. Yes, Arvind. Now, in so far as their submission is concerned, they're saying it's 1/3 according to the sale deed.
Yeah, 1/3 amount. That's okay.
Yes.
That's a kindly notice the tabulation.
No, but they're saying that this amount of 54 lakhs is the entirety of the sale consideration. But they're saying, now, do you have a copy of the sale deed?
Like these figures, we have taken from their returns of 17.
No, but
It's not
they're,
our figures. Not our figures. It's their figures from the returns. But in that, what has happened? The showcase notice is issued for something else. The reply is for something else. We are not on 45/5 at all. 45/5 will come in 17/18 or 18/19. There is a different issue. But here, page 51 for the minute, you also can. But they sold on 25/7/2016. Consideration is 54 lakhs. Another sale deed 2/6/2017. Consideration is 60 lakhs. But against these considerations, they claimed 40.91 lakhs and 42.40 lakhs as cost of acquisition or improvement in the 17/18 and 18/19. Whereas, this 83.31 lakhs together, they are claiming to have incurred the lot for the assessment in 16/17 has not been offered to tax. Is not disclosed in the return itself. That you also kindly notice down below. Just below the table. We are not on the capital gains. Whatever they have given the figures, they are showing the figures. What the Singh officer is saying, you are claiming of expenditure of 83.31 lakhs in assessment in 16/17. Your return for 16/17 does not reflect return of this expenditure. That 83.31 lakhs is the same assessment. This is the only simple thing. 83.31 is their figures. But the assessing allot is 18/19, saying I have incurred 80 lakhs expenditure in 16/17. But whether the assessing officer is not entitled to repeat to whether 83 lakhs accounted in 16/17. Whether it has been offered to tax or not, disclosed it or not, that you will also to find below the table. In view of the above, the income of 83.31 lakh is represented in the form of assessing expenditure respect of transaction exceeding tax, say, which is chargeable to tax is suspected to be escaped assessment of 16/17 within the meaning of clause 2 of one of 149 rated 147 lakh. In view of the above, the amount of 83.31 lakh is not disclosed by the assessee and remained untaxed and hence has to be brought to tax for 16/17.
now, where is the returns of the SSC? Just produce the returns.
But these figures for the cost of improvement details claim this from their return. But there is no quarrel, the first transaction will fall under 17/18, second transaction will not fall under 18/19. In those respective years, but they are claiming lot of expenditure incurred in 16/17 as a deduction. But if the expenditure itself is unaccounted in 16/17, you cannot get escape in 16/17 and also the deduction in 17/18. But what has been taxed because why the cost of improvement has been allowed as a deduction? It amounts to capital expenditure. It will not be allowed in the year in which it is incurred. It value addition to the capital asset. Because that has been incurred as an expenditure in the year of sale, but the capital expenditure gets reduced. Otherwise, it will get taxed twice.
It will be taken note of only in the year of sale.
The year of sale, because already it is taxed in the year of incurring. But it gets to not allowed its expenditure plus 649, 48. In the year of sale.
Now, in the year on which it is incurred,
it is not disclosed in the return. That's why what is coming whether there is something offered to tax something or not. Prima facie it was not offered. Figures were not.
now the improvement in the year of actual.
Their claiming we have incurred in 16/17. That's what we have got to.
No, so you are saying not having declared. No, but have you shown it in the year in which you have incurred that expenditure?
Can go. These are things.
No, the cost of,
Also, we have, I have, because we have sometimes.
now this cost of improvement in the year in which it's actually incurred cannot be claimed as an expenditure because it's a capital. But you're saying that should have been declared.
Value addition plus, that out of stuff. But otherwise, what happens? Unaccounted income gets converted into asset. Really, because cost of improvement is available, but it will not get automatically allowed in the year of sale.
Unless it is a.
It gets escape in the year of expenditure and also it gets allowed in the beginning of sale. The matter of 1780 and 1890. About 40.91 and 40.4. All these figures in the table is being taken from their own returns.
Let us see. Now you file your objection. We'll consider it. We'll have to hear.
Get the assessment go on. It's not
In the treatment, I find probably not safety and also the calculating. So it might not be something that is really.
Only issue of the thing of the study 1617 is 83.31 lakh. I thought will account for. But I was noticing then 51 in the last era. They came to not 1617 is offered to tax or declared in the return. And they don't want to say
Can we go 45 by 8? Can they take up this case for 1617?
No, they're saying that they will not rely on 45(5)(a).
They are not saying anything about 45 by 8.
They're saying that they will not rely on 45(5)(a), but this capital expenditure of 40 lakhs and 42 lakhs ought to have been declared in the year when it was actually incurred in the return filed. In the return of the relevant year. That is, if you have claimed improvement in 1617, then
and there is a time limit for stop. Can they go 1617? Can they
is it within the limitation?
And they are clearly only the tax. But 83 lakhs is the amount. On the face of it.
that is
No, but in 2 different years.
No. Sale is in 2 different years. Incurring of this 83 lakhs for not 1617. It is their statement, not our statement.
So the entirety of 83 lakhs is
1617. And 80 lakhs, 50 lakhs. On the face of it.
Yes.
no, the finding of the order authority is 83 lakhs 31,893. Where have you stated that is not coming? It's only incurred in 1 year alone.
Hey, what she want? She sent something and all. She called me. Okay, I told her. Okay.
No, now you will just you produce the returns for having declared this 83,31,893 in whichever year. You just produce that, we'll have a look at.
Yes, trying to stay for. Final return. See that.
Yes. 83 lakhs 31,890. No, that you show in which year you have declared it as a capital expenditure. Sixteen, 17. Yes.
And in 17, 18, just for my 17, 18, 18, 19, they are claiming 53 lakhs about said to have been incurred amount for the assessment in 16, 17. What the assessment scheme is now also not let them show that 83 lakh has been reflected in the return and tax not for 16, 17. We have not, this has nothing to do with 17, 18, and 18, 19.
17 can they go through?
The notice.
The place of it,
If that so, not beyond 50 lakhs. By producing the painting. Yes. Within that 11 years.
The one is the capital gain is a different aspect. They're saying that the cost of improvement ought to have been declared in your return in the year in which it was actually incurred, which according to them is 16, 17.
Later years.
That you show from the return where you have declared. We'll have it on.
Proceedings of pending. Can they? If you notice that I think the policy, but now, they are all notice and for
Why two notices were issued? Why two notices were issued with respect to the same assessment year at annexure D?
He issued notice for the cost of improvement is 20. It's not accounted for, I want to assess.
Yes.
They have filed a reply along saying that 45 fine is not applicable. That's why to say that I am not on 45 you can 17 on the cost of improvement, issue one more notice for there.
Okay. We'll have it on Wednesday.
Because if we ask for 16, 17, they gave a reply it is not taxable for 17, 18.
Orally advise them to hold their hands for a week. We'll see on Wednesday. Relist the matter on next Wednesday. I've instructed him. Details. Huh? Yes. Yes. Statement of objections to be filed by the next date. Relist the matter after 3 weeks. Yes, next. The counsel for R4 and R5 is permitted to correct the memo of appearance. Yes. Interim order earlier granted is extended till the next day. ಚೆನ್ನಾಗಿದೆಯಾ? ಓಪನ್ ಆಗ್ತಾ ಇಲ್ಲ 20 12923. Yes. Page. Yes.
What is,
140. Yes. It was signed on 10/5/23. Yes. This is the show cause notice. Seven days. Page 1.
Starting here, applicable for this. What would the relevant position is the page number 130? 72. I don't know, but let me find it on 115.
Now, assessment order, he says reply not filed, is it? Page. Yes. Yes. Yes, son. The yes, yes. All, yes, the petitioner has sought for setting aside of the assessment order dated 19/5/23 passed by respondent number 2 under section 147 read with 144 capital B of the Act at annexure A1, comma, has sought for setting aside of the computation sheet at annexure A2, comma, setting aside of the notice of demand at annexure A3, comma, and has also sought for setting aside of the penalty notice at annexure A4. Petitioner has also sought for setting aside of the notice under 148 at annexure B1, comma, setting aside of notice under 148 capital A small b at annexure B2, 148 capital A small d within bracket B3, and the notice under 148 at annexure B4. Petitioner has also sought for setting aside of the instruction number 1 of 22 at annexure C. The counsel for the petitioner submits that the assessment order is liable to be set aside on the sole ground of violation of principles of natural justice, as the show cause notice at annexure as the show cause notice at annexure J was issued on 10/5/2023, seeking for a reply before 15/5/23, which time for response is contrary to the SOP applicable for faceless assessment. Copy of which is produced at annexure T. Full stop. Attention is drawn to clause N.1.3, which observes that the time for response to a show cause notice ought to be 7 days from issue of show cause notice. Full stop. We submitted that as the in the assessment order, it is observed that there was no show cause, no reply to the show cause notice. The assessing officer has proceeded without any reply from the petitioner. He submitted that in light of the inadequate time that was available to make out a response, which time limit is contrary to the SOP relating to responses, relating to time to be given for response to the show cause notice. It is submitted that the assessment order may be set aside and fresh opportunity may be afforded to the petitioner to make out reply to the show cause notice. Next. Perused the show cause notice at annexure J. It is clear that the notice has been issued on 10/5/2023 at 6:14 hours. The response was directed to be made by 15/5/23. The time that is stipulated for response is in clear violation of the applicable SOP at 10.1.3, which requires that at least 7 days time be given for the purpose of making out a response. Next. It is clear that the plea of prejudice caused to the petitioner and violation of principles of natural justice is a contention that requires acceptance. Accordingly, on the sole ground, the show cause notice, the matter is remanded to the stage post show cause notice at Annexure J dated 19/5/23. Full stop. The petitioner is at liberty to make out his reply to the show cause notice at Annexure J and the authority to afford all opportunities as is permissible under law and proceed to complete the proceedings. Full stop. All contentions of the petitioner are kept open. Full stop. Counsel for the petitioner submits that the aspect of limitation is also to be kept open. Said submission is taken note of. Accordingly, the A1 to A4 are set aside. The matter is disposed of subject to the above observations. Yes. Learned counsel for the petitioner submits that the validity of instruction 1 of 22 has been challenged, which has been challenged in the present matter, has been challenged in other writ petitions as well, including in WP 13013 of 2023. Full stop. It is submitted that an interim order has been passed in the above mentioned matter and the interim order may be passed in the present matter as well on same terms. Interim order passed in WP 13013 of 2023 reads as follows. Next. Accordingly, there would be an interim order of stay of annexure L1 to L5. This is the matter along with the WP 13013 of 2023. Full stop. The respondents to file the statement of objection and the liberty is reserved to seek for modification / vacation of the interim order if circumstances are so made out on filing such objections. Seal number IE. 43. Petitioners filed IA 1 of 23. seeking for amendment of the impleading. This is 44, isn't it? 43. Angela? 43 no 4. Yeah, the word. 12497. 43 na. IA 1 of 23 has been filed. Seeking for amendment of the writ petition to include in the prayer column prayer relating to quashing of instruction 1 of 22. Petitioner has also sought for a prayer to implead Union of India Ministry of Finance, Central Board of Direct Taxes as third respondents. Where is the proposed amendment? No, you have to say, isn't it, after which para you are introducing? That is not, huh? After which para, where the paragraph numbers come, which portion of the prayer is to be, that you file a fresh application, that is. No, that I'll consider, but this application you file separate. That's between. Aye, bada. Learned counsel for the petitioner would submit that the validity of instruction is sought to be challenged in the present matter also. Full stop. Noticed IA 1 of 23. However, as there are certain technical defects, petitioner to comply with such defects and liberty is reserved to file fresh application seeking amendment. Nonetheless, notice that the contention of the petitioner is also as regards validity of instruction 1 of 2022. It is submitted that in an identical in WP 13013 of 2023, where identical issue was raised, an interim order was passed, which reads as follows. Next, accordingly, there would be an interim order of stay of annexure A, B, C. Full stop. Liberty is reserved to the respondents to seek modification/vacation of the interim order if circumstances are so made out. Full stop. List the matter along with WP 13013 of 2023. Now, in this matter, you are already on record. Copies to be served. Yes, yes. But this issue has not been resolved in any other high court. Now, who appears now? Who is a respondent? Learned Council. Huh? The serial number 3026. The council for the petitioner submits that the challenge in the present writ petition involves the question of raising service tax demand based on declaration under in the income tax assessment proceedings, and in another writ petition raising identical legal question, this court has passed orders, interim orders in WP 11154 of 2023 on 1/6/2023, which reads as follows. Accordingly, there would be an interim order of stay of annexure, order at annexure A. This is the matter along with the WP 11154 of 2023. Yes. Yes.
अबे ये लोग मुझे आइडिया नहीं, 2-2 मिनट में केसेस 10 केस हो जाते हैं, पता है क्या करते हैं?
No. No, there are not. No. Yes. Still, this issue remains unresolved. 129, 130. What is the effect according to you?
Woman application is And when they are able to prove that there is evasion of tax, or documents accompanying the vehicle, the small other than documents, small penalties are levied. Otherwise, penalties are levied in the 129, 128. In other words, this is a classic case of good being totally documents. And it's transported in the night. The vehicle, it was, this is the vehicle was detained somewhere, checked around somewhere around.
No, what is being confiscated?
It's scrap material. When it was intercepted, there were no documents. And the documents that were provided 2 days after the detention was all created after the vehicle was released. It's not a case of defective document, it is a case of transportation of goods without any documents. And summons have been issued to the driver of the vehicle, to the owner of the goods conveyance, as well as the petitioner. Statements have been recorded from the driver, who says, I don't know, I was asked to pick up the truck from this particular place in Kolar and deliver it to another place. And how the goods came into the goods vehicle, he doesn't know. Petitioner comes forward and says, we have made purchases from unregistered dealers up to 1 lakh, or from each person up to 1 lakh, and transported it by way of auto and then put it into this goods vehicle. The owner of the goods vehicle says, I did not take I don't know what was being transported or being transported from I just sent a driver along with the goods vehicle. And it is a case where the owner of the goods vehicle has come forward and paid the penalty and got his vehicle released in the block. Conveyance has been released. We are only holding on to the goods because it was being transported without any documents. And with regard to the argument whether it has to be done within 6 days or it can be further extended, and regard to whether 130 is applicable or not, I'll have to detail argue the matter. This is not a case with granting of stay orders.
No, goods, what you want to do with the goods?
These options.
That will decide. That will decide. So you file your objections, and then we'll consider. No, let us see, we'll hear it. No, that you stay, we'll hear it. We'll stay the auction, we'll hear it.
I don't think auction notice. I don't have instruction. I don't think auction notice. Because this order of confiscation is passed on 20th of April 2020.
No, we'll allow the order of confiscation to stay. We'll only say no further action. You file your objection, we'll hear the matter. Insofar as now, pursuant to the order on 130, you intend to auction it.
Goods have been confiscated.
Correct. We'll allow that to stay. After all, it's not perishable, isn't it? So we'll allow that to stay. Further action of auctioning, etc., you hold your hand, you file your objection, we'll hear them.
But have it explained as well. I can orally able to convince my lord.
AGA. Submissions will be made on the merits of the matter next week. In the interregnum, respondents are not to auction the confiscated item. Such direction will be imposed in the next day. Relist the matter next Wednesday. Now in Dharwad, there was that one order was there of the single judge that has gone to the division bench. What has happened there?
All the central authority,
And the single judge's order has been stayed. Stayed.
I think it is stayed. I don't have the order copy, but because central authorities were state is not a part.
No, but this the legal question is still not resolved.
It has to be again, because one is procedure is just like that.
You have a look.
Cases of bigger offenses, as I mentioned earlier, defective invoice or a defective EVA bill, spelling mistake or mentioning of PIN number 2 digits of wrong. These are all minor things. I wonder if there is any discrepancy in the codes. In after the disciplinary verification. And as I mentioned, if the owner comes forward, we can use penalty. Owner doesn't come forward, it's penalty at 1. Here, this is a case where one of the grounds. Once you make an order, within 6 days, you have to pass an order.
There's one.
I'll be able to explain rule 138 and corresponding rules. Which rule pertains to detention?
No, now suppose it is seized when you intercepted it in the check post. Now there is some option, I think, isn't it, that you can come forward and pay the.
But when you provide it under 129 money is when the driver when the owner of the goods come forward. Even if there is an he pass an order, collect the penalties and deal.
The procedure follow.
Even penalty is levied at 129 money or 1B. 129 1C provides for release of goods upon furnishing a bank guarantee. Upon furnishing a guarantee, the bank guarantee is provided in the rule 140.
Now that option can be exercised at any point of time, or what is the position?
Before any orders are passed.
Before order of confiscation is passed. After confiscation.
After confiscation, what will be 130 minutes? 130 plus 2. Provided after confiscation, they can be released only upon payment of fine. There's still an option that they can pay the fine and get the goods.
Now here the order of confiscation separate after that separate order regarding fine.
In the order of confiscation, it is a total composite order. Confiscation as well as and the fine is arrived in the order. That fine and penalty can be paid and they can get the goods. That is what subclause 2.
So before confiscation procedure of 4 etc. has been done. Hearing.
All the procedures that are prescribed knowledge has been followed in, especially in this case. I can demonstrate only by reading some portions of the impugned orders.
Let us see next witness. Yes. Yes. Under section? Yes.
Yes.
So already for the same assessment here, proceedings are pending in. Where do you get that, Aniksha? No, you are saying that for the same assessment here, 148 proceedings are pending before the Commissioner of Income Tax. So where do you get that reference? The no, but have you stated any references there? Alright. Now for the same assessment year 14-15 fresh notices. Orders also. How can you have two reassessment proceedings regarding the same assessment? So we'll stay till then. Now where is the present assessment order and notice? In the present reassessment order that was passed after 148, you raised this contention that previous for the same year already one matter is pending.
That's the page note 31, relevant note 33, page 33. Not made any sort of representation for jobs.
Let us see, we just observe that much. The counsel for the petitioner would submit that the assessment order passed under 147 pursuant to the notice under 148 for the year 14-15 at annexure C requires to be interfered with in light of pendency of an appeal against order passed under 147, also pursuant to 148 notice for the same assessment year 2014-15. It is submitted that there cannot be two sets of reassessment proceedings leading to orders passed, assessment orders passed. In light of said submission, the order at annexure C is stayed till the next date. Respondents to file the statement of objections and are at liberty to seek for modification/vacation of the interim order on filing such statement of objections. Yes. Page. This is the inventory. Yes. Yes. We'll continue at 2:30.
My lords, with your lordships, kindly leave
Just
my
1 minute. Just 1 minute. Just 1 minute. Yes. Yes. As it is submitted that counsel for R1 is not appearing in the matter and represents the Gulbarga, which is Discom. And court notice may be issued once again to R1. Taking note of the submission made, it will be appropriate that presence of R1 is ensured to a legal counsel. Accordingly, issue notice to R1, emergent notice to R1 afresh. That counsel is there, local counsel. Yes.
My lords, with your lordships, kindly.
Yes.
Serial number 37, my lords.
Yes.
May I request for it after 2 weeks?
Serial number?
For the petitioner, serial number 37.
Yes.
I can dispose of.
We want some time.
Unless my lawyer has any objection, matter can be remanded back to the authority. Only to that point.
They are saying the matter could be sent back to the assessing authority on that point.
My lords, then may I request for it in the coming week, my lords? The learned senior, Mr. Dathar, had appeared in the
Sir,
matter.
Arvind Dathar was appearing in the matter.
Please, my
There was
lords,
a suggestion
please have
made
some
that
inconvenience.
the point with regard to
Correct.
sale of
Now you
agarbatti.
get instructions, sir. We'll see. We'll have it next Wednesday and dispose it off.
Very well, very well.
This is the matter in preliminary hearing list.
Very well, very well.
On next Wednesday.
I'm grateful, my lords.
You could have found out. You could have disposed it off.
My lord, senior had some inconvenience today.
Yes.
So therefore I sought for time. I'm grateful, ma'am.
Yes. Seal number 40. Call along with. Write and give it.
You want to make it.
230 ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ತಗೊಳ್ಳಿ.
Serial number 36 ಆಗಿದೆಯಾ ಸರ್?
36
ಹೌದು ಸರ್.
ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ. ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್.
ಈಗ ಬಂದ ತಕ್ಷಣ ಪಾಸ್ ಓವರ್ ತಗೊಳ್ತಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 6.
Sir, serial number 6 would be called first.
Yes.
Thank you, sir.
Yes. Serial number? Time ಆಗಿದೆ. Then you just wait. When it reaches, we'll see.
Pass over matter. Serial number 6. Ashwin Kumar. Serial number 6.
May it please your lordship. But I'm sorry for the inconvenience caused in the morning. Lord, in fact, I was logged on to the video conference. But my lord, I'm sorry I missed my item. Lord, I was logged on.
No,
I did
that's
not.
There
Obliged,
must have
Lord.
been some
Obliged.
Yes.
This is a case where
You are
the
seeking a
limited,
writ of mandamus, isn't it?
yes, my lord.
So you take out notice.
Yes, my lord, I'll
Take
do
out.
it.
Take out notice.
Yes, yes, my lord, I'll do it.
The Commissioner, Chief Commissioner of Customs, you will take. Learned Counsel C. Jeevan Niralgi accepts notice for the first respondent. Emergent notice to respondent number 2 and 3. You want to take out notice by way of hand summons? I leave it or just emergent notice?
Emergent notice, my lord.
Emergent notice to respondent 2 and 3. Yes. Sometimes if in case we find some noise in one of the participants, that time the court officer will mute so that the other conversation
I understand.
goes on. So it
Lord,
may
I
be
understand.
some mistake like that.
Yes, my lord, I'm extremely sorry.
No,
Lord, in
that's
fact, your lordship has been most gracious, my lord. I stand obliged.
yes.
Obliged, my lord.
Yes. Just a moment. Yes, what are the facts? Yes. Yes. Yes.
They cannot stop immediately go order was followed by the other High Court. Thereafter, the order was confirmed. Apart from the there is additional notes on that. This case, not make an addition on that. Okay, you are setting the filing movement once you are that. Regard to particular moment, how is the High Court judgment?
Where another kindly this was not.
Third provisor to 132.1. No, that's okay. Let's see. We'll find out from them. Yes.
It says that it is not arriving. And it's
Yes. Okay. Let us see. Let us.
Kindly turn to Malan page number. My turn.
Yes.
There's 51 paragraphs. Search was conducted on 2/12/2021.
Page 50.
Page 51, madam. Second page of that. Second paragraph.
Yes.
The search was conducted on 2/12/2021.
Yes.
End of the relevant financial year is the about 31. And the assessment year will be 22.
Yes.
Not whatever the old malad is in CS. That is to be assessed malad for 22-23. The assessment proceedings are not. The statute provides for malad to retain that gold, but till beyond 1 month after the completion of the assessment.
What is that?
But for this malad assessment proceedings on the what 12 months, my lord. That's for kindly turn to section 153, page 1.10.
One point.
102. There's one, my lord.
Yes.
Order of assessment shall be made under section 143 or 144 at any time after the expiry of 21 months from the end of the assessment year if this income assessment. But this is 21 months, my lord, from the end of the assessment. End of the assessment year would be, my lord, 31 May 2000. From there, but 21 months. That's what kindly turn to, my lord, there is a change. At page 1.1028.
Yes.
That's what kindly notice, my lord, just above 1A, proviso, my lord, in italics.
Yes.
Provided also in respect of an order of assessment relating to the assessment year commencing on or after 1st day of April 2022. The provisions of this subsection shall have the effect as if the word 21 months, the word 12 months has been substituted. Now, in view of the provision, we have to read it as 12 months from the end of the assessment year. But that would be, my lord, 31 weeks. Hence, my lord, the question of, my lord, the adjusting that either cash or the gold, that doesn't arise, my lord, is my first submission. But the second submission, my lord, is this entire gold, my lord, is found to be unaccounted. But what my learned friend is contending that not he is in the business of gold. Anything and everything found in the premises is a stock in trade. But to constitute stock in trade, my lord, there should be a purchase register, stock register, sales register. There is a requirement under the law, my lord, that to maintain the stock. They cannot tell anything and anything not found relatable to the business, my lord, is stock in trade. Now, my learned friend, my lord, is seeking to challenge that seizure. But under the guise of challenging the assessment order of assessment year 2021-22. But 2022 is the include assessment order at the section A. But we have not made any addition on that basis. This is altogether a different issue. And they have not been provided an opportunity, they have participated. But a statutory appeal under section 2.6A has been provided for. That's what kindly notice the first page of the assessment order, my lord, I say.
No, his content, one of the contention is once you have rejected the books of account, you cannot.
That is on merit, but appellate authorities will deal with that. The dusting officer has rejected the books of account for the reason that they have shown some expenditure, bogus expenditure. He has rejected it and he has disallowed the entire expenditure of applying 37 and 48. Because those expenditures were reflected in the form of a cash. They could not even identify the person. That's why Maladi has rejected the books and
he has not relied on those books.
The books they submitted, Malad was not substantiated, hence he rejected the book.
Correct. So, whatever he has done is without reference to the books.
No reference to the book. But once the authority says, Malad, I have an expenditure of 10 crores, the thing of that doesn't accept the supporting documents. Books of accounts are rejected. But he cannot ignore the statement of the claim of 10 crores being spent. That is what he did. That is a factual exercise.
Now you file you file a statutory appeal.
I balance it up. I mean, this is the associate pressure. Our event assessment here. For that, returns only has extracted the money about.
No, now you file an appeal against this order.
Statutory provisions is there, both
No, that is a different matter. That we'll see.
That
No,
assessment
just-
order is two different matters.
Insofar as the seizure, we'll look at it differently. Insofar as the assessment order, you file an appeal.
That is my additions, how it is, by the assessment party. Only once assessment party has accepted it, it's all about. Very. That is the assessment order for that.
No, we'll hear it then. Then you file your objection, we'll hear it.
Okay, but the correctness of rejection, the books of accounts are not as to be not examined. Actual exercise, that reason only, apply the practice of conduct.
No, I won't say it. We'll hear it. That's all. I have week after next. Let them file their statement. This is a matter of appreciation after a finding of fact. You'll have to go on a regular appeal.
Based the assessment order has been passed, the extracting about the.
You were heard, isn't it? You were heard in the proceedings.
That is the, I am agreeing with this part of
That will consider. Appeal is filed. So then on this aspect, we'll hear it. We'll hear it. No, that we'll hear it. We'll have it week after next on that position of gold. We will see what is to be done. Now in the pending appeal, no, if an appeal is pending, you will seek the relief there only. Why can't you raise it before the appellate authority? No, does he? No, correct. Now, only question is whether the appellate authority can consider the same contention what is raised here.
So far as release is concerned, because it is subject to 22-23. Appeal is relatable to 21-22. You cannot go beyond Malad. And also, Malad, the statute provides not in the seizure has been made. Provides for filing a representation, Malad, seeking release of the single article.
He has not done that.
They have not done it.
132. Then you do it. No, Mr. Counsel. 132B.
132B1, I'm sorry, one of it. At page 1.924. 1.92.
Subclause?
The asset seized under 132 or requisition under 132.
You're reading subclause?
Plus 1. 132B11.
The proviso to subclause 1, isn't it?
Yes,
so you make a representation under the proviso. They'll consider it. Under the proviso to 132B1. First. December 20. You find out, get instruction. You find out, I'll have it next week. Find out what has happened to them. We'll have it next week, find out. Counsel for the petition. Next week we'll see. Let us see. Learned counsel for the petitioner submits representation has been made on 29 December 21 regarding release of gold and cash. Revenue to take instructions and submit regarding the status of the said representation. This is the matter next. Yes, next. On 4. On the 19th. Yes. Yes. Yesterday. ಸ್ವಲ್ಪ ಮುಗಿಸ್ಬಿಡೋಣ ನೋಡೋಣ ಸ್ವಲ್ಪ ಆಗುತ್ತೆ ಎಷ್ಟಾಗುತ್ತೆ. So what's the interim relief you have sought? Stay off. On what ground you are seeking? Learned counsel for the revenue submits that matter requires filing of statement of objections for further consideration by this court. In light of the said submission, in light of the urgency pleaded, there would be an interim order of stay off. J1 and J2 in the next date. Respondents are liberty to move for vacation modification of interim prayer on filing statement of objections. Yes, next.
30.2, my lord.
Learned counsel Shri Sushal Tiwari undertakes to appear for the respondents. 30.2. Now the interim relief is common to all. Huh? The common order sheet. Huh? Common order sheet. Yes, next. Learned counsel 30.2. Yes, next. Yes. Hem Kumar, you appear, is it? First time it's coming over. So what is the matter? Correct. Now, the appealable order.
Already covered in
The appeal order. And then against that,
Tribunal is not valid.
that has to be heard. No, then you file your objection, we'll hear it. And in the interregnum, the response. Let us see. respondent to file the statement of objections. In the interregnum, the impugned order at annexure A and B are stayed in the next date. The respondents are at liberty to move the matter upon filing statement of objections. Same order. E and yes. Next. Passover. Yes.
35, my lords, please, my lords. My lords, I am audible?
Yes.
Yes, my lords, this petition is filed challenging a show cause notice and the impugned DRC 01A.
Just 1 minute. Yes, who is the contesting respondent? M. Kumar. You are the answering respondent. Yes. This is the first time it's coming, or you? Yes, what is the case?
My lords, actually, my lords, in filing GSTR 1 returns, we have committed some mistakes and we have sought to rectify them. The second amendment which we filed, that was rejected by the respondents on the ground that it was filed after the due date. And the impugned show cause proposes to levy the tax on the turnover which has not been effected by the petitioner. My lords, the amount of turnover which was entered by us was wrongly entered in that.
Yes, what?
So, my lords, we are seeking this writ for allowing us to amend our petition. Once if the petition is amended, the show cause notice then would not survive because there would be no demand under the show cause.
Yes, M. Kumar. Let us see. We'll relist it week after next. They want to take instructions.
My lords, meanwhile, ad interim stay could be granted because they are seeking to adjudicate this matter. I have received the notice. My lords, you may find it on our memo presenting now.
It's Canada. Huh? Otherwise, we'll have it next week. You get instructions. Relist the matter. Next week, let's see. We'll consider your interim
may be granted.
Next week.
My lords, until then, kindly request for status quo.
Nothing will happen next week. We'll see. We'll consider your request next week.
Obliged. Obliged.
Yes. Passover. Yes. Passover. Once I take the parted matter, Passover will be passed over to next week. Yes. Next Wednesday. We'll have it next Wednesday. Relist the matter on. Yes. Next. Passover. Passover. Passover.
My lords, item 42
Yes.
My lords, I appear for the petitioners.
Yes.
My lords, similar writs are pending, my lords. There are three writs already pending where notice has been issued.
3 writs by the same SSC.
My lords, 2 by the same SSC, 1 by a sister company. Same issue. My lords, the first writ is the order is at page number 117.
Now this must be tagged along with those writs.
Yes, my lords.
Learned. Yes, central tax. Jivan. Land Council Jivan Niralji accepts notice for respondent 3, 4, assistant commissioner also 5, and then 6. Learned Council Madhanan Pillai accepts notice for the first respondent. AG accepts notice for respondent number 2. List the matter along with.
My lords, WP number 5347 of 2022.
5347 of 22. Yes.
My lords, there's an interim prayer also.
Interim prayer in the connected matter has been passed.
Yes, my lords. If you see, my lords, at page number 118.
Page 118.
Yes, my lords.
No, but on what ground interim order was given in that matter?
My lords, basically, they are rejecting our refunds and also issuing notices on the other side, asking us to pay the tax, saying that you have not exported services, now you pay taxes.
Now you have challenged the rejection of refund in the present.
Yes, my lords. Yes, my lords.
There would be an interim order restraining the respondent from taking out recovery proceedings. Insofar as the amount of refund is concerned.
Yes, my lords.
Yes. List along with source. Yes.
Obliged, my lords.
ಇದು ಯಾವ್ದು ಒಂದು ಪರಿಸ್ಥಿತಿ ಆಯ್ತಲ್ಲ ಯಾವುದು ಆಮೇಲೆ ಹಾಕಿದ್ರು. Yes. Very good question. Now, before we start, I just have one query. Now, in the event, according to you, they have not followed the circular, which says don't issue notices blindly. In sum and substance, that's what you're saying. That even where there's exemption, they've issued without application of mind, and that circular is there. Then can it not be that we ask them to reconsider it, apply their mind, and get back? That is without entering into the merits.
The foundation of the case is not many cases different to what is there. Depends on what is what we focus on. What it's the back. It's focus on focus on the issue. Higher manner. Don't even negative acts. Let's say you send letters, you are replying to video. Many of these cases are not understand. Some of them also sometimes they issue this kind of notices and correspondence. But the lead matter is chosen to actions to affect them. Start accepting the proceedings. They're not even seen. Even for both point of service, rendering services. Statement on this. There is no sending it back doesn't arise. That is our point. That is what but there are cases about where there is a element or some amount of services having been rendered. They are already in the saying what not made moving and going. Cannot take 26 years and keep listening to the notices to all customers. Due diligence, seeing that intent is something is a service. It's not the course of the system.
So you take one of the lead matters.
Yes, okay. Yeah. Page now. Let's start with the provision. Say the text.
Yes.
Yes, right. Three pages.
Yes.
That will be stand with the direction to summarize the where there is no tax application. Example, sale of goods, very short process tax. When the order system, that is one. Second, my lords, where the services are not taxed and they present in the negative list. By definition, negative list cannot be part of this. They are part of this. Just by relying on the basis. Even my lords, where the services are exempt, specifically exempt, even that they're part of it.
Legal services of litigation lawyers or what?
Yes.
Litigation lawyers are exempt.
By doing it for a individual, an exempt. By doing it for a corporate economic category, first time. Where the lawyers are not subject to tax, corporate pay tax. So these cases become clearly double tax. Where I collected tax from the corporate, but I continue to issue notice to the tax. So this is what is. These are cases, this is how I invited all these factors. They will fit in one of these categories. They don't fit into this category, then they are released. They fit into this category and not matter. So then it will become a jurisdiction. trying to say my lord is this. Essentially, some tax money. I think that my lord several streams. Income. But all of them will be on account. Have an interest income coming from the bank. Have to pay income tax. Then can pay STT returns. I will not be required to do this. That's not paying tax. Let us figure out. Let's see the scheme of the act. Service tax. Let's see who are liable to be registered for not why they are liable. Okay. Why I am saying that there is no jurisdiction. Service tax act depends on who's liable to pay tax. If they are registered for liable, our contention is please. Page 16.
Yes.
Services. Other than those services specified in the regulations. Right? Any tax. Other than that in the regulations. So provided a protection. It's not all incomes on which this is derived. Where only services are provided for use. Then I also see the negative use page 18. In 1950, first they say the tax is not leviable. For example, we got services with the Reserve Bank, services relating to agriculture. That's not class B. For example, E, trading of goods. Then my lord uses selling of space. Service by your access. Services again with your lordship. Services by your renting of residential dwelling. Like this, if your lordship just turns the page 20, page 20. For example, after 14/5/2016, even education was exempt. And after 2016, sorry, 2016, education was on the negative list. After 2016, it was transferred to the exempt.
Exempt.
Exempt. They issued an exemption notification 25 that this education. This is the scheme that fits. Rather they feel that it is not being taxed upon at the threshold, they put it in the negative list and say at the threshold you don't want taxes, and the charging section excludes.
But why they don't want to charge betting, gambling, or lottery?
Yes, statements. So, every as per every party, there is regulations can be framed in the list of laws. Taxation comes from the end. Therefore, to the state list, there are several reasons. For example, that is trading of goods, trading of goods is under the state bank. So it comes under the negative list. Because farming is subjective.
Yes.
The Lord, they declared certain service, not important for us. 66 is the date of valuation of that. It comes now, my lords, 68, which is at page 28. Payment of service tax. It was for providing tax. Rest of the section. Then lordship comes. 68(1) says provide service, you pay service. 68(2) is an exception. Notwithstanding anything contained in subsection. Respect of such taxes notified. Service tax thereof shall be paid by such persons the rate specified. All provisions of this chapter was the right of paying tax related. Why did the central government service? How will the chapter affect the remaining part of the service tax shall be paid? The effect of this cannot 68(1) says the general rule is person who provides the service pays the service. 68(2) says there could be cases where the recipient is liable to pay service.
It is for the central government to
notify.
note.
That is for administrative convenience. Cannot, for example, auditor renders certain services. No way the government will collect tax. So they make the recipient liable. Likewise, goods transport operators, where it was difficult to collect tax, they made the recipient liable. Similarly, they clubbed all the advocates also in that category and told that the charge will liability will shift to the person who receives. Charge will remain the same. Liability shift. Receives the recipient. In line with this method, they made two sources to a DA based selected. The rules of the tax rules. Page 39. Particular 1D. Page 39.
Yes.
Person liable for paying service tax. They set out, I want to read all the entries. One or two entries what they meant. For example, kindly come to page 40. Please come to E. Entry D. Relation to service provided or agreed to be provided by an arbitrary tribunal or an individual advocate or firm of advocates, whether legal services, other than the representation. In all these cases may not the recipient will be liable. The default clause is found in page 41. Small 2. Small 2. That case other than subclass 1 means to provide us. Calls subclass 1 recipient will be. No calls subclass 2 only provided. It's a language.
They have difficulties in recovering it from lawyers.
Not so many words. It is neatly hinted that they are put along with GDs.
I read your mind. Yes. Yes.
And once it's hidden, intention of service. So so included. I got it on page 90. 68 refers to what the central government will notify. That is at page 97. 31. Lordship sees this notification, the same rule is produced. And then they set out at page 99 how much proportion will be paid by who. The Lordships would kindly come to entry 5 on page 99.
Yes.
Respect of services provided or agreed provided by mutual activity. A firm of advocate whether legal services direct or indirect. The Lordship is nil and 100%. 100% Lordship sees the following meaning. Percentage of service tax payable by 80% direct or paid service tax other than the service. So effectively they make the service recipient. This is the scheme. This scheme may not who they want to register. Very important because the current issue is not other. It's on page 20.
Page
29, section 69.
yes.
This page, every person liable to pay the service tax under this chapter of the child. It is such kind of such manner, such powers. Central government will make a notification. This is a general process of classification. We should make an application. This is for the service is provided under this. Emphasizing one. Every person liable to pay the service tax. So Lordships are already aware. Chargeability to tax and liability to tax. Chargeability is check matter. Liability depends on the assessments that I make. Service tax provisions envisage that only if you are liable you need to register. It's my lords. Also in exemptions. All my services are negative. They are not liable to pay tax. First of registration. The question of registration does not happen. Question of demanding tax from me or issuing show cause notice. That is the reason why I have not registered the first. So distinction may not be made between what is charged. If they said every person chargeable to pay the service, then everybody has to register. But they deliberately said only liable to pay because those who are actually liable to register, those are the exempted list or in the negative list. They don't want them to register. Still, those exemptions are those lists. Therefore, my lords, keeping this in mind, next page, section 7. Publishing of returns, every person liable to pay the service tax and use of versus the tax due on the provided. The return in such form, I want earlier of the return. All the time, trying to say, they are also not the same liability. They don't switch up. And self-assessment. If you give self-assessment, that's why 73 notices. Recovery, it comes at page 15. We've read 73 many times, not up to hours. Where the service tax has not been levied or paid or not levied as part of the others, the state tax is officer making the payments. What presentation my heart system? If I am not liable to pay at all, we are still not coming to 73. Liable to be registered. We are still not coming to 73. You can't issue a show cause notice, then say, to clarify whether you are liable or not. That is the job that you are supposed to. Take a 26 years form, my lord, let us take a form from some other department and they are sharing information with you. We get that information and I am supposed to sift through the information and see that there will be democracy issue. Better to the assessor say, between this an inquiry has to be done. Once a reply is filed to the inquiry, my lord, under section 14 of the Excise Act, I will show you a lot. After the inquiry is there, I am still not convinced and I find out from the result of the inquiry. Something is because there is a service element part. I do my due diligence. Then you should focus. Because notice is not an empty formality. Yes. Government that they are white discuss only a proposal. It's not so. Because notice is the foundation of the case. So I'm also convinced that it's not. Service has been done and not taxed.
Is a provision under which show cause notice is.
23. Reading of first. Serve notice on a person chargeable that it has not been levied or paid, which has been shortly shorted of the person who is substantial. Regardless, requiring to show cause why he should not pay the amount specified. Notice was very why? Because all the notices, as I see here, could be exceptions. All the 8 or 9 matters, especially that are stated under the provision issued. Why that matter is has not been levied or paid or has been short-levied or short-paid. Or error is implemented the reason on fraud, pollution, mistake. So that is not facts. Contravention of any of the problem is checked. When the person charged with the substantial problem for the world 35 years. They say if these ingredients are ignored by God, the limitation will be 5 years. Otherwise, it will be 30 years. The normal period of limitation is 30 months. Extended period is 5 years.
That also has to be verified.
It's just a question of fact and what country. Where the facts are not in dispute. Facts are not in dispute. Then, my lords, it becomes two questions. Suppose my lords, that means it is against the exempt institution. What is this? Not any issues. Becomes a pure question. That is why even this background, I classify this into 4 categories. Not come back to page 2. Keeping this in mind, we classify this 4 categories. Obviously,
A, where there is no taxable income. For example, seller, it falls under this state. B, where the services are not taxable and the revenue taken. For example, education. C, where the services are exempt. D, where the services are taxed and have interest. Knowledge for cases are submission is simply this. All of this is case. Not having initiation. But then my Lord will see. What is the case laws say? What are the propositions? What are the case laws say? Where the show cause notice can be issued? What is the role of the show cause? They will say it's after all proposal, you can answer. It's not so. What happens? Now you can take it as a page 3. First ground demand. This is demand of service tax for basic. Section 73 cannot makes it clear that the charge has to be made against. It says why something has not been levied or not levied has to be brought to a notice. Show-cause notice by law is the foundation of adjudication. Adjudication to the show-cause notice should not be based on others. And we provide enforce those decisions here also. And no application from and even no material. This is important. First of all, the foundation of the department has to be the allegation of the laws all part of the vague details and or that is sufficient to hold the notice not to proper. It's what the right. That is not sufficient to get it in the form unless they ensure that they are partners. First of all, it is much less needed than the part substantial standard. The commission and first of all, it's not bringing home the allegation. They are only vague allegation. The notice itself may not specify what is the service element that you want to tax. If you don't put it to that notice, what they will simply say that based on the idea, all these have been brought to tax, and then they show you later how it has been done. Then they not, I do not know what I mean. It's for very clear proposition. It's not clear so that cannot issue possible and take just suffices. The next case also out to the very famous case. All is created. This is also why not there is the other basis on this is very relevant to know as I see some 4 or 5 applications right. They take 26 days for 1 year. Some income. Say 26 years, 4 year income is 3 lakh. Next year income is 70 lakh. We estimate a 20% growth in the 3rd year. And I show those notices also. And what will these other three case laws directly or not be demand. Given charges so enough for government to tell him that his answer was unsatisfactory. Rather than this because they required nothing further the government will the no hesitation to take care of the state. Manifest clear the focus way information, the appellate will be effective. Then consequently, the order of section class on so the standard what is it? Just give you notice on what exactly the issue is. You can't be expected to be what should come to be in Madras High Court decision. Starts from 13 is the relevant paragraph. Relevant paragraph. 13 and 14. When an allegation is made, the burden is on the person who alleges beyond doubt. The burden can be discharged only on the basis of concrete evidence, at least stated. There are variations. It is also strictly law that the show cause notice issued without any tangible evidence and based only on inferences involving unwarranted assumptions. It's vitiated where error. This is the important point. In this case, the department assumed that the signatures of the business were based on examination. Such a presumption unless deemed clear evidence. Vitiate proceedings itself is canon. And not like the rest of the paragraph because it only goes to add. Why my lord says that the focus notice not specific as vague, it has to go. There's no question of resurrecting the focus notice by saying that matter. Go back and he comes and actually gets. That doesn't arise in this. Income tax matter I am showing as prospectus service matters, tax, excise, just to show your lordship consistent you get across legislations. That is why I am showing it across legislation. It's the income tax. Of course, therefore, petitions did not know what yes, they had to meet and they really given the response. Submission of the petition deserves acceptance to focus on the day and then delay ballot. Point that the first one is the foundation of the next, and if you not have been based on 26 years statement without further inquiry and putting notice, what are those items on which they want to tax? Because ultimately, burden of
Before issuance of show cause notice, procedures provided for inquiry also.
Inquiry, they write a letter, many of the cases, next one, showing that we are not accepting. And the case was, they are going to go on. It clearly said that we call reverse charge, very extent, record all this. Spite of pressure, lead by code is named after CMH hospital, everybody knows it. CMH hospital gets issued a notice and an order. That the order says you are rendering medical, you are running a hospital. You are rendering educational service. Proceed to control it. In all these cases, inquiry done, replaced by some cases, focus on many cases, focus on converted to orders also. That we have been saying. This is as far as fundamentals of SOCAS. Therefore, that is why I said at the beginning, we got that the SOCAS notice is spontaneous. So another thing, if they want to issue another SOCAS notice, completely or then I got demand of service tax in the second law. It's 4. What is said in all these cases? A lot of sees. Search is done. I get unaccounted money. This information is shared with the sales tax. Sales tax department automatically raises it from customers. You have to account for this under the sales tax. Understanding. Maybe income there. Need not necessarily have arisen on account of sales. That is the case. The Supreme Court lays down the law, my lord, very clearly there. That is a taxable limit under the Income Tax Act. Under the Sales Tax Act, there is no sales, you can't bring it. What is it? Very clearly. That's okay. Six of the flags there is statement. Maybe this is imposing liability payment and unexplained acquisition. Cannot afford the sales tax. Purpose of income tax inappropriate is unexplained tax. The assessing income from under the purpose of levy of sales tax necessary not only for not getting explained, but also before the existence of the regulated to indicate that it's not money assets has resulted from transaction liable to sales tax and not from others. Based on this, I got all these cases because this was already mentioned by this what is trying to say the Lord cannot take that data and put it. That is what I'm saying. can't take the income tax data and put it in service tax and say whatever income is there, you will pay tax unless they are able to show that there is a service element. That is exactly the case. It's three matters, the case which I cited. First case, the other follows. And you must obey follows, in CCEP might be also follows. Take all this point. Take all this. Regular decision, which has been upheld similarly, it becomes a matter of law. That kind of hang the law prior to income tax would be payable on either seat basis or on two. Service tax was always on the seat. They will do the same thing. They will take the income tax returns and confirm. What is the tribunal statement? What is paragraph 2.1 page? Terms of the award, service tax cannot be awarded based on the returns. And the provisions of income tax that are clearly bounds to the returns. Why in the case of service tax, they are also not taking credit at the end. There is also pressure not the ratio. I take that data and extrapolate or superimpose it on the service tax account. That might not have been 149 gets come from that you get that. Delay can go the appeal system. It's the statement of the law as far as same if you got yes, the home foundation case, yes, most of these. What is also a point of taxation. So this better say. Case where my lord, petitioner was able to witness and showing your lordship's worst case, where itself it has been the demands have been brought to the name. It's a case where my lord is liable to make services. What is the further on verification, the profit and loss account of now with service tax payment not paid appropriate. When the explanation offered to the petitioner to effect point of taxation due to the government time of release and consequential approval of receipt and direct not the clear accounts of respondent was adopting financials for the determination of service tax liability as well.
What para 17 says, I will just not performing to explain. This is a firm which does construction. Construction contracts can be treated in two ways. As and when I construct and receive money, I can afford for receipts and payments. Or I can follow even the completed contract method where I take all the income during the year in which it
That option is there.
that option. It would go either this is required payment, but when it comes to such tax, it's for income tax. When it comes to service tax, they don't give this. They say as and when you get the money, you should pay it. So obviously, my lords, how I approach it in the profit and loss income tax is completely different from the tax which I'm paying. But ultimately, I will pay tax some year or the other. On that there is. But here was a case where my lord service tax authority insisted that there is a difference, they won't tax. What they do, my lords, is they take that year where there is an excess of income in the income profit and loss over the service tax and subject it. And go on give a set off to the next. This was that means. That is why my lord the Honorable High Court would find it para 80. Foundation the assessment is just in my view law. The SPL calls upon the assessing material support of the stand. Paragraph number 11 states the audited balance sheet of the financial statement recorded, etc. Becomes submission for the basis of issue of the case. By way of replying, the petitioner or source of scope explains interrogate in the PL account cannot be the basis of this. Impugn orders passed, notwithstanding objections raised again. There are cases where they simply taken the PL account and confirm the service tax. Then by lord, they will very clearly be not paragraph. Petitioner enters into agreements with customers construction of apartments. The agreement provides for demarcate and stage wise from on the completion. Payments are to be released. The additional service results in the approval of the receiver transaction. Setting out all those paragraphs, they very clearly then paragraphs say that is to the and they very clearly also say that paragraph 34 may not set aside this order of process. On the ground that service tax and income tax, the provisions are. This is a case where a lot of these options have already seen this. After trying to say, even if it is a case where there is a tax being levied on our existing Honorable High Court has held that make income tax the basis of charging because it's a jurisdictional act. Can't make that the basis. Go as per the service tax. Income petitions and engaged here at least there are 4 petitions from case. The computations are based on activities. I will show you in those petitions how they are done. Regarding the initial years are made on the basis of declared facts. All the subsequent years, the respondents are taking ad hoc increase because the demand. There is no provision in the Finance Act for the adoption of ad hoc perspective. They are not taken the medicines so next year and done. They have not done that also. They have simply taken an ad hoc 20% and added in 4 out of the 8 petitions. I come to another important issue here before I got to the detail. See the doubts whether at the outset itself, the roaming inquiry they can
right? Not know take the 26 years. Instead of analyzing it, further, you tell me what is it. I presume it is all tax. You tell me what. That is very important for us. Determining all these things. So far as the relation to such extent, that's the other relation to then not second line.
Yes.
Let's see what they are an inquiry. That is supposed to be. Yeah, the stage of inquiry which precedes the focus, what are you supposed to? Any central excess office power by this do not be. About some of the stuff evidence problem inquiries and the central excess office will be empowered with central government and have power to summon any person either to give evidence or to produce topic or any other thing. Such officer is paid for any of the purposes. Someone to produce documents or other things may be for the production of certain specified documents or things or for the production of all documents of a certain description. The possession or under the control of the persons. There are two categories. Production of certain specific documents. That has to be under. That is category one. Category two may not see. Not ensure process. Start the inquiry as information in this possession. It shows that there is something as escape taxation, any other process. To say no, you should ask production of those documents satisfied. They should be specific documents. Or all documents of a certain description. You cannot, my lords, in the guise of using section 14, simply write a letter and say, I have the 26 years with me. You produce all the documents. And that be done. That is the issue. That's the role of the query against anyone. On the ground that I don't have the detail, I can only see the 26 years. Produce. That it is not a service. Regards section 14 arguments. Reason that said Kato, question that can be asked is
What is wrong with him asking? Kind of. Why can't he ask for any document? Without specifying, he can ask any document. Why does the section build in this certain specific document? He said, my lord, this document is so wide, it is cut out at the document. Orbit test is cut out there. This is the section 4 says, relative and distributor, you select through him. The price matrix, the relative of the distributor cells will be the price at which drug takes it. I select my relative 100 rupees, I select him. He sells it at 200. Tax on which I will pay is 200, not 100, because presumes. When I sell it for relative or try to suppress the price, pay less exchange, it profits. The terminology uses relative and distributor. Supreme Court said it is not every distributor can be taxed. Then it will become very wide and liable to be struck down under article. Only that distributor is related. So they read down section 4 in Bombay Times. Let me add this. And that is the reason why my lords, section 14, I request. So that the roaming inquiry is not started. They have pinned down the discretion of the office to ask only for relevant information. What is relevant is next. Now, I can't issue 10 and 86 case. Simply say you produce whatever. Now, in this context, only my lord that circular. Page 210. Substantial amount of damage is done, they reduce October 2021. How would I say it? 210. Presentation is the Department of Revenue CVA. Presentation it is paid for association. But in instance, issuers of demand notice, this is this regard, the understand is directly from that CH guidance. Consideration statement has to be part of the taxpayer bills. Whether the service from earned by the corresponding period negative services paid in section 60 of the Finance Act or exempt from payment of service tax to any reason was further reiterated that demand notices cannot be issued in this based on the difference between ITR PD taxable value, the taxable value of service. Is once again reiterated that instructions for cost of ITR PD data. The service tax returns only have a proper verification of tax to be followed diligently. Then they say that what has to be whether commissions. In spite of this, they still continue. I say they got price to put that. But before you issue a notice, please do your due diligence. Therefore, my lords, I would say that there cannot be indiscriminately issues costs. The data has to be analyzed. But they say that you receive it from the income tax authorities. Kindly analyze it. Directed in what directed the government and analyze the ITR. Prior to the inquiry stage in Congress, analysis. Then if you find that there is verifiable services, they issue an inquiry under section I don't reply to get satisfaction. Then the show cause notice. First, my lords, self-analysis, then by of the data, followed by inquiry.
It's like 148 AB.
You will notice then tell me, I tell me what is not. Yeah, because you come and show me what is tax not tax. I don't do anything. That is why I'm not circular process. Why not the circular variation? See what happened in the lead matter. See, this is the formulation of the scheme here. And going inquiry apart from this laws is 20 minutes.
I think one of my brother judges also received. One of my brother judges also received notice. And he was a little unnerved because the assessment order is passed.
They have data to show I have printed. What should see is now here I just read the headnotes from summons for product of wholesale documents. Even summons. That is why my lord has said section 2. When you make a summons and it can be only specified documents. This is the case now, my lord. Supports that proposition. Right? You cannot take the idea data and tell the person what is all the documents. I will see what is to be taken or not to be taken. Wholesale production. That was struck down by this one of our releasing parents. Specifically, my lord must say that wholesale document cannot be done. The lordship should see. Page 220, paragraph 18 is the issue. My lord, this is value material is section 73 of the finance. 11 of Excise Act. So from where my lord 73 of the Finance Act, the wordings are not identical. So going into the validity of the other rest of the studies, they observe in passing we initiated as a serious authority at the bank cannot be permitted where collect material or its initiation by directing wholesale production of documents, making a only fishing inquiry for purpose. After all the problems that including section are meant to be addressed, that identification is without cost unnecessary harassment. In this backdrop, my lords, we will have to look at it. Actually, if I satisfy these, then my lords clearly still not supposed to go into very simple cases. Straight away, my lords, focus this is the notices and consequent orders. I will just one now time. Take the
Which writ petition? Manjunath. First 54 scan ಆಗಿದೆ.
Lawyers petitions also may not. You can clear up in that. That is because the lead candidate may. Supposed to be the inquiry manual, which already pointed out a lot of that only for specific topics. Non-payment is not non-payment regarding then let's get with effect from 1/7/2012, all services start next that is studied from the relevant income tax records of financial year. It appears that the whole substantial but have not paid or short paid service tax corresponding period tax. Financial year, sale of service tax or ITR 26 days follows. Sale of service tax or service tax due. Because requested to submit within 3 days of receipt of the reconciliation statement regarding this. This is my last during the COVID period. So this is the leading hospital. That's the service. If they are unable to reply within 3 days, give them a reply, which is at page 18. Then they set out all these things.
Now this is the issue.
This is my
Super.
last inquiry. So far, the inquiry. So they did not ask any specific document. It's a roaming inquiry. What I have declared, how you just do? I don't know. That's the final justification may not be indicated on purpose. May not have it is said that I asked them for time. It is right. Specifically, is going to 2021 when all this happened. That told them give me time. That I want. Focus on time. Section 8 page 30. At 2.1, I got third time. The result of the income reflected the ITR returns. 5 years. And for 26 years in the financial year, see the service provider and however, they have not declared the said income, the STP figure. Out of it is the first certificate. This is the charge with the layout of the page 40. Not coming to page 40, you see this. Second paragraph, the lot is appears that the service provider has received a total amount of 7,41,000. We see that figure
Come down and see what is the figure that we give. 11 crores 61. I don't know, this must be 160 crores. 11 crores 61, 66, 350. And 7 crore amount. We are not sure. So where they got this? God should say page 111. These figures are coming from the IT database. God should see the IT database page 111. For a moment, that is part of the aggregate attribute. I have trust. I say I have trust, but I have CAT exemption. And then I have charitable trust and exempted from income tax. Come down by marks. Find a figure at some. If it goes. We have absolutely no basis. Because of this, they just check the income tax return. See that it can. Assuming my not for most of it, portion of it is taxable. Which portion is so the next check a lot. First, you can't ask for a movie. Second, focus on specific. What is the sense? Fourth, failures. Third, reimbursement. Automatically. Automatically.
Just 1 minute. We'll continue on next Wednesday. Thursday, that other matter is there. You can finish and come. Huh? I'll be doing the regular list. But after I hear them, after I hear you on this test case, we'll hear them. But then afterward, we may have to take up each file.
ABC. The focus on this. These connects not data. Then we can test each one of this. Constantly focus on this. If the satisfied like this, hopefully that comments here.
Then your other report, they must also, the other petitioner can also, you can have some coordination so that it becomes simpler when we come to the second stage. Yes. The matter for further sharing. Yes. It is. Tentatively, we'll have it on 12. Yes. This is the matter on 12th at 2:30. Interim orders in all matters which is in operation stand extended in the next.
Rather than every hour similar on that and this time
They are exempted. You just mentioned that exemption, that category, there is something. Yes. No, we'll no, correct. So we'll simplify those in the negative, exempt, like that. No, so one table may be made, and you put it on the notice board. We'll give permission, and then the petitioners, this 1, 2, 3, 4, your category, even for arguments, they can so that they can also volunteer, give information. Exempt directly like this we will. Yeah. Let us see. We'll think. And in case of lawyers, any further clarification we require, or we can close it, we'll close it. But you find out by the next date. If that is clear, then this list we can remove it. So then you submit it on the next date, and you meanwhile you verify for those 6, 7 lawyers. If all details are already available, you can make a statement. You can only say that they are lawyers. Documents have been given to that effect. Remaining we will take. Only to the effect that you have information regarding they being lawyers who are practicing. Yes, yes. And counsel for the petitioner. AGA is directed to accept notice to the first respondent. This is a delayed claim of ITC. Learned counsel for the petitioner submits that the legal issue relating to delayed claim of permissibility of delayed claim of ITC as is also being adjudicated in other writ petitions, including in WP 10232 of 2023. It is submitted in the said writ petition. The coordinate bench, referring to the interim order in 6256 of 2023, has passed an interim order which reads as follows. Next. In light of the same, subject to further consideration, there would be stay of Annexure A. Annexure A and F, subject to petitioner depositing stay of Annexure A. Stay of Annexure A, subject to petitioner depositing 10% of the tax assessed within a period of 1 week. Full stop. On such deposit, the order of attachment of at correct. Annexure F. The attachment of the bank account. Where do you get the details of the bank account? So which account has been 30?
Account number.
In particular,
The order of attachment of bank account.
bank account bearing number of the page 38. So and so would stand lifted. List the matter. Now you have to club this with the list along with the WP 10232 of 20. Order stands extended in all matters which are in opposition. Dates you can take from the court office. Right, so the court officer will give dates. Number 53 in preliminary hearing list. Yes. Serial number, orders list. Serial number 48. Manjuna, 48 orders list. 44. No. You can make request. Yes.
37.
Yes. Preliminary hearing list.
ಸೇವ್ ಮಾಡ್ಬೇಕು ಇನ್ನ ಮಾಡ್ಬೇಕಿಲ್ಲ. ಸೇವ್ ಏನೈತಿ ಇದೈತಪ್ಪ ಮೌಸ ಎಲ್ಲೈತಿ.
ಎರಡು ಸೇನು
ಅದೇ
ಅಂತ
ನಂಬರ್ ಕೇಸ್ ನಂಬರ್ ಬರ್ದಿರ್ತೀನಿ ನೋಡೋದು. ಕೇಸ್ ನಂಬರ್ ಬರ್ದಿರ್ತೀನಿ ನೋಡು. ಕೇಸ್ ನಂಬರ್ ಐತ್ರ ಕೇಸ್ ನಂಬರ್ ಹಾಕೊಂಡ್ಬಿಡು. ಸಿಕ್ಸ್ ಸೆವೆನ್ ಅಂತ ಮಾಡಿದ್ವಿ ಸೇವ್ ಮಾಡಿದ್ವಿ ಕಳಿಸ್ತಾನ. ಮತ್ತೆ ಬಂದಿದ್ದ ಹೇಳ್ತೀನಿ ಹೇಳ್ಬಿಡ್ತೀನಿ ಈಗ ಮೇನ್ ಸ್ಟಾರ್ಟ್ ಆಗ. ಬಂದ್ಲೇ ಕೊಡ್ತೀನಿಲ್ಲ. 2 weeks. ಡೇಟ್ ಇಲ್ಲ, ಡೇಟ್ ಬೇಡಲ್ಲ. ಮೌಸ್ ಆಫ್ ಮಾಡಿಲ್ಲ, ವಿಡಿಯೋ ಆಫ್ ಮಾಡಿಲ್ಲ.
What up, sir? Sir, yes, sir, sound. Sir.
ನೀವು ಯೋಚನೆ ಮಾಡಿದ್ರೆ ನಾನೇ ನೋಡಿ ಬರೀತೀನಿ ಯಾವ ಅಂತಾನೆ ಇಲ್ಲ ಇದು ನೋಡಿ ನಾನು ಬರೀತೀನಿ ಒಂದ್ಸರಿ ನೋಡಿ ಕಾಮನ್ ಸೆನ್ಸ್ ಇಲ್ಲ ಮಾಡ್ಬೋದು
What up, sir?
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್
ಕೇಳಿಸ್ತಾ ಇದೆ. ನಮ್ ಧ್ವನಿ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್?
ನಿಮ್ ಜೊತೆ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್
Okay.
ಕೇಳಿಸ್ತಾ ಇದೆ
Yes,
ಎಸ್
sir.
ಎಸ್ ಸರ್ judgment, serial number 1, Vasaraja Kareddy.
I picked up that.
Just ask your please to
Appeals are allowed. The award passed by the senior civil judge Basan Bagewadi dated 29/1/2015 in LAC number 61 is modified. The appellants are entitled to market value for their land at the rate of rupees 8,80,050 per acre. The appellants are also at liberty to move the competent authority and claim damages in terms of the observations of the apex court. In the case of RL Jain Supra, in the event they have material to substantiate their possession has been taken prior to section 4(1) notification. The appeal is allowed in part. Judgment and award dated 13/6/2018, passed in MEC number 882/2018 by the senior civil judge and MMCT Anand is modified. The appellants petitioners are held entitled for enhanced compensation of rupees 29 lakh 47,000 together with interest at the rate of 6% per annum from the date of petition to realization. Number 2, to indemnify the compensation and deposit the same within 4 weeks from the date of receipt of certificate of the judgment. On such deposit, the tribunal to take approved steps to deposit the amount in the name of petitioners and also make payment as per terms of apportionment so passed by MSCT. Petitioner number 1 is entitled to drop periodic interest on such deposit.
I'm appearing more appellant, my lord.
Appeal filed by the appellant under section 19(1) of the Family Courts Act is dismissed. Judgment and decree dated 25/9/2020, so passed by Family Judge Kalburgi in MC number 177/2017 is hereby confirmed. No cost. The appeal is allowed in part. Judgment and award dated 16/3/2020 passed in MEC number so and so is modified. The appellant's petitioner are held entitled for coming up with 28,52,000. This is computed to deposit the amount. Six and seven deferment. Six. File for
Number 6.
Five, my lord.
ಇದರಲ್ಲಿ
My lord.
ಇದು ವಿತ್ ಕನ್ಸೆಂಟ್ ಆಫ್ ಅಪೆಲೆಂಟ್ ಇದೆಯಲ್ಲ ಇದು
My lord, 5 or 6, my lord.
ಸಿಕ್ಸ್ ನಂಬರ್ 6
Nagaraj Patil 6.
5, my lord.
6.
ನಾಗರಾಜ್ ಪಾಟೀಲ್ ನಾಗರಾಜ್ ಪಾಟೀಲ್ ಇದಾರಾ?
ಇಲ್ಲ, my lord.
Third reserved ಮಾಡ್ಬೋದು. Third further reserved. ಪಾಪು ಗೌಡ ಸಿದ್ದಪ್ಪ ಇದಾರಾ?
I am against the appellant.
ಫೈಲ್ ಕೊಡಿ ಫೈಲ್.
For respondent number 2, my lord, insurance company.
ಇದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ತಾವು,
Yes, lord.
ಈ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ ಇದು ಇಸ್ ಇಟ್ ಅವರು ಅದರ್ ಸೈಡ್ ಅವರು ಒಪ್ಕೊಂಡಿದಾರಾ?
Yes, lord. There are please, my
ಕ್ಲೇಮೆಂಟ್ಸ್
claimants are the claimants are seeking announcement.
ಥರ್ಡ್ ರಿಸಲ್ಟ್ ಮೊತ್ತ ಮಾಡ್ತೀವಿ.
Please, my lord. Kindly, my lord, one submission.
ಹೇಳಿ.
5, my lord. Serial number
5 ಆಯ್ತಲ್ಲ, 5 ರಿಸರ್ವ್ ಆಯ್ತಾ, 6 ರಿಸರ್ವ್ 5 ಆಯ್ತಲ್ಲ ಈಗ.
Number 5. Bhimarage serial number 5.
Appellant, my lord. Announcement, my lord.
ಎಸ್ ಎಸ್
KSRTC ಅವರು ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ, my lord.
ಎಸ್ ಎಸ್ appeal is allowed in part. Judgment and award dated 12/11/2019 passed in MEC number 380/2017 by the principal and decision rights is modified. The appellant petitioner held entitled for enhancement of his 12,74,256 with interest at the rate of 6% per annum from the date of petition realization. Response number 2, NEKRTC is directed to deposit said enhanced company numbers within 4 weeks from the date of this receipt of certificate copy. On such deposit, it not to take appropriate steps to deposit the amount in the name of petitioners and also make payment as per the apportionment so did. Petitioner entitled for drop periodical interest on deposit.
And
Appeal is allowed. The judgment and award dated 17/6/2020 passed in MEC number 6/2019 by the second edition senior civil James is modified. The appellants are entitled for enhanced coming of fees 34,40,424 together with interest rate of 6% per annum. This form to deposit said amount. Appeal filed by the appellant under section 19(1) of Family Courts Act 1984 is dismissed. The judgment and decree granting decree of divorce passed in MC number 1/7/2020, dated 27/1/2022 by the principal judge, Family Court Pleasure is hereby confirmed. No cost.
I am offering for respondent number 2 in insurance company. Serial 10.
The appeal is allowed in part. The judgment award dated 25/7/2022 passed in MEC number 6/96/2020 by the senior judge MACT Jivar is modified. The appellants are entitled for rupees 5,98,000 to the interest at the rate of 6% per annum. Include deposit the same.
Hearing 11, led by government advocate.
Appear for the respondent state, my lord.
I just have one clarification. That sketch was produced.
Please, my lord.
Just go to the sketch.
Separate memo, my lord, that is.
Correct. So, in that sketch,
please.
There is one which is in yellow.
Please, my lord.
One is a stripe, color stripes.
Yes, my lord.
Now, in 1151155 bar 1 and 1155 bar 2, isn't it?
Please, my lord.
So now that yellow portion is refers to the existing road or proposed acquisition of highway, or what is yellow portion? If you turn the legend, yellow says ಭೂ ಪರಿವರ್ತನೆ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನಿನಲ್ಲಿ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 167 ಹಾದು ಹೋಗಿರುವ ಬಗ್ಗೆ ವಿಸ್ತೀರ್ಣದ ವಿವರ. So what I want to know, whether this yellow portion which you have shown in the sketch refers to the existing road or proposed acquisition, or what is this yellow portion?
This portion is not a highway, state highway, state highway road is there.
Look, it is running through the respondent's land.
Yes, sir. This is from R to, it is mentioned R, no, it's ROIGA. This is yellow, it is marked, that is.
Correct. So what I want to know, whether this yellow portion is the existing road running through his property or proposed for acquisition. That is one. Two, yes, whether the road is in existence already, but you need to acquire it.
That is that point, my lord.
So the road is in existence, but not yet acquired.
Yes, yes.
I will make it clear, my lord, that is after getting the instruction.
Correct. So I'll fix one more date.
Please, my lord.
What only doubt for me was now insofar as the sketch is concerned, whether that yellow portion refers to proposed that you will have to acquire it or not. That
yes, my lord, I will get
one. The reason why I'm saying is suppose now he is going to claim compensation because tomorrow you are going to acquire it. He may say that because the as on today it is not yet acquired, the value that may be taken for converted land will be higher. So he may say that since as on date it is not yet notified, the fact that it is there is a different matter. He may say that let the price as on the date of notification be taken note of. Now the second question which I want you to answer is, let's assume that it is not acquired, but is it your case that even as on date this IJQR, which is that yellow portion, is the existing road which is being used, though not acquired? Is it so? That you have to clarify and let me know.
Please.
So similarly in this 1155/1, this ABFG, that is the place where which is still to be acquired, is what Mr. Reddy says, which you are saying is the proposed road. So you find out that. Then this GFJI, these are dotted lines. GFJI. Now this is not colored anything. So what is this? That is in different survey number. It does not relate to 1155/1 and 1155/2. That's why it is not shown.
Yes, Lord. This is lands belongs to the another lady, my lord. This is
Okay. So that we are not bothered.
Yes.
So in the top portion and bottom portion, that yellow portion refers to that is land wherein existing road is there but not acquired and proposed to be acquired. That one clarification I require.
Please,
so yes, Mr. Kareddy.
I will just try to refresh, my lord, the things. What happened? What is the matter, my lord? The ADLR and National Highway authorities were present before this honorable court, and with reference to map, extensive discussions were held. What has happened, my lord? And they have told that the existing portion which they say there is an existing road and which my lord sought clarification, that portion is not acquired. Now that map area portion is sent for acquisition to the Bangalore office. Only one SLO office is there. My lords may kindly recollect it. Then my lords asked, not yet notification is issued, more than 1 year has lapsed, etc., etc. Those discussions have taken place.
Yes.
For this, my lord, what has happened, this existing road, what they say, on that they started work, my lord, the so-called existing road. Then I opposed and approached this honorable court. Kindly look at the additional documents filed by the government advocate along with their affidavit. There, my copy of the writ petition is there. Thereafter, my lords can go for that order portion also. I suppose in page 8 in the additional documents that writ petition copy is there, my lord.
Yes.
Kindly turn to para 3, my lord. Para 3 dalli, my lord, relevant portion. So basis.
Just 1 minute. Just 1 minute. ಒಂದು 50 additional ಆಗ್ಲಿ.
ಇದರಲ್ಲಿ ನಾನು ಬೇರೆ ಲ್ಯಾಂಡ್ಸ್ ಅವನು ಅದಾವ ಸಾಹೇಬ್ರೆ. ಆ ಥರ್ಡ್ ಪ್ಯಾರಾದಲ್ಲಿ ಆಫ್ಟರ್ 7 lines ತಾವ್ ನೋಡ್ರಿ. ಅಂಡ್ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಇದಕ್ಕೆ ಹಾಕಿವಿ ಅಂದ್ರೆ ನಾನ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ದ ಪಿಟಿಷನರ್ಸ್ ರಿಕ್ವೆಸ್ಟ್ ಟು ಕಂಡಕ್ಟ್ ನೆಸೆಸರಿ ಸರ್ವೆ ಆಫ್ ದ ಲ್ಯಾಂಡ್ಸ್ required survey of the lands acquired in order to determine the area of actual acquisition made by the respondents in order to widen the road is presenting this writ petition, my lord.
Yes.
Then kindly turn to para 6, my lord. It is further submitted, married.
Yes.
It is further submitted that though the above mentioned certain lands of the petitioner, the lands are mentioned in para 4, my lord. These lands have also come. Though the above mentioned certain lands of the petitioner found place in the notification issued by the respondent number 1, the respondents have undertaken the project in the lands which were not acquired and not mentioned in the preliminary or final notification. Kindly mark this, my lord. Contrary to the provisions of so and so, so and so, the petitioner, after noticing illegal works undertaken by the respondents in the lands of the petitioner, objected the same by contending that the lands on which work was going is not acquired by them and no compensation is paid by as per law. The respondent, without considering so and so request, was proceeding with the work. Hence, the petitioner approaches so and so, so and so. So, I will not take much of my lord's time. Ultimately, my approach to this honorable court in that writ petition is the same grievance. Again, ತಾವು ರೆಡ್ ಪೋರ್ಷನ್ ತೋರ್ಸಾರ ಮಾಡ್ರ ಅಂತ ತಿಳಿದು ನಮ್ದೇನಂದ್ರ ಇದು ಅಕ್ವೈರ್ ಮಾಡಿಲ್ಲ ಏನಿಲ್ಲ, ಇವ್ರು ರೋಡ್ ಹಾಕಕೈತಾರ, ಅದಕ್ಕೆ ಇವ್ರಿಗೆ ಸರ್ವೇನ ಮಾಡ್ರಪ್ಪ, ನೀವು ಯಾವ್ದು ಅಕ್ವೈರ್ ಮಾಡ್ರಿ ನೋಡ್ರಿ, ಅಂಡರ್ ದ ಗಾರ್ಬ್ ಆಫ್ ದಟ್ ನೋಟಿಫಿಕೇಶನ್ ಯು ಕೆನಾಟ್ ಡೂ ದ ವರ್ಕ್ ಹಿಯರ್ ಅಂತ ತಿಳಿದಂತ ಬಂದೆ ನಾನು. Kindly turn to the order of this honorable court on that. ಇಲ್ಲಿನು ಆರ್ಡರ್ದಾಗನು ಐ ವಿಲ್ ಟರ್ನ್ ಟು ಪೇಜ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ 4 ಆಫ್ ದ ಇಲ್ಲೇ 4 ಲಿಂದಾನೆ ಓದ್ತೀನಿ. 3 ಪೇಜ್ 3 ದಾಗ ಆರ್ಡರ್
at page 22
ಅದೇ ಆರ್ಡರ್ ಆಫ್ ದ ಕೋರ್ಟ್ dated 30th June 2021
page 22. Yes,
ಆಯ್ತು ಸರ್. ಪ್ಯಾರಾ 4 ಸಾಹೇಬ್ರೆ.
yes,
so and so ಇವೆರಡು ಸರ್ವೆ ನಂಬರ್ ಬಂದವ. ಐ ವಿಲ್ ಜಸ್ಟ್ ಫಾಸ್ಟ್ಲಿ ಸ್ಕಿಪ್ ದ ಥಿಂಗ್ಸ್. so and so the respondent number 1 issued a notification under so and so provisions of the act expressing the intention to acquire adjacent lands. So and so issued a preliminary notification. So and so. Next, the respondents have undertaken to widen the road so and so in the land which were not acquired and not mentioned in the final notification. The petitioner, after noticing illegal work undertaken by the respondents in the land of the petitioner, objected that the land on which the work is going on is not yet acquired by the respondents and no compensation is paid as per law. The petitioner has submitted a representation dated so and so requesting the respondents to conduct the survey by the officials of so and so, Raichur. The respondents have not considered the representation so and so has filed this writ petition. Okay, kindly turn to the operative portion. Other portion may not be necessary for the present purpose. The writ petition is disposed of with a direction to the respondents number 3 to depute Assistant Director of Land Records to measure the aforesaid properties of the petitioner and fix the boundaries in respect of the landed properties within a period of so and so after receipt of so and so order.
So now my one clarification, as on date, whether the work is stopped or they've made off a road and they're using.
Stop.
So there is no existing road in your property.
Side nallide sahibre. What has happened, my lord, in that map only, illena nakashe grammar raste anta ada nodi sahibre. Idralli actual fact ಹೇಳ್ತೀನಿ. ಈ ಗ್ರಾಮ ರಸ್ತೆ ಆದಲ್ ಸಾಹೇಬ್ರೆ, that is in records ಅದು ಹೈವೇ. ಇವ್ರು ಏನ್ ಮಾಡಿದ್ರು ನೋಟಿಫಿಕೇಶನ್ ದಾಗ ಅದಕ್ಕೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬೇಕಿರೋದ್ರ ನೋಟಿಫೈ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರು. ಸೊ ನಾನು ಒಂದ್ ಸೆಕೆಂಡ್ ಬಸವಟ್ಟೆ, ನೀವು ಕ್ಲಾರಿಫೈ ಮಾಡೋದು ಒಂದ್ ಸೆಕೆಂಡ್. ನಾನೇನ್ ಮಾಡಿದ್ದೆ, ಸೊ ಇದು ತಪ್ಪಾದ. ನೀವು under the garb of just mentioning my lands in notification, you cannot lay the road wherever you like ಅಂತ ಹೇಳಿದಂತೇಳಿ I approached this honorable court.
So now that Grama Nakashe Yante Raste is outside your property.
ಹೌದು.
No, that is wrong.
ಈಗ ಬಸವರಾಜ್ ನೀವು ಆಮೇಲೆ ಹೇಳಂತೀರಿ, ನಾನು ಸಾಹೇಬ್ರಿಗೆ ಕ್ಲಿಯರಿಫೈ.
Facts must be clear, that's why.
ಅಲ್ಲಲ್ಲ, ಫ್ಯಾಕ್ಟ್ಸ್ ನೀವು ನಾನು ಕರೆಕ್ಟ್ ಮಾಡ್ರಿ, ನಾ ತಪ್ಪು ಹೇಳಿದ್ನಂದ್ರೆ ಏನ್ರಿ. And my lord, the ADLR and National Highway authorities have even told to me, when my lords ಅವರೆಲ್ಲ ಮ್ಯಾಪ್ ಅದು ತಗೊಂಡು ಬಂದ ಮೇಲೆ kindly have discussion with the respondent council ಅಂತ ತಾವು ಹೇಳಿದ್ರಿ. They showed the papers and discussed with me. My lord, video of the court is not visible to me.
Just one video ನೋಡಿ.
Yes. ಆಯ್ತು. ಈಗ ತಾವು ಅಫಿಷಿಯಲ್ಸ್ ಬಂದತ್ನಾಗ ಈ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅಂದ್ರೆ ನನ್ನ ಜೊತೆ ಕುಂತು ನೀವು ಅವ್ರಿಗೆ ಡಿಸ್ಕಸ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರಿ, ರೆಕಾರ್ಡ್ಸ್ ಅದು ತೋರಿಸಿ. ಅವ್ರು ಡಿಸ್ಕಸ್ ಮಾಡಿದತ್ನಾಗ ಅವರು ಹೇಳಿದ್ರು, ಸಾಹೇಬ್ರೆ ನಮ್ಮ ಕಡೆಲಿಂದ ಇದು ಮಿಸ್ಟೇಕ್ ಆಗ್ಯದ, ನಾವು ಇದು ಅಕ್ವೈರ್ ಮಾಡಿಲ್ಲ, ಈಗೇನ್ ರೋಡ್ ಪೋರ್ಷನ್ ತೋರ್ಸಕತ್ತೀವಿ. ಆಕ್ಚುಲಿ ಇದು ಗ್ರಾಮ ನಕಾಶೆದ ಏನದ ಇದ್ರದ್ದು ವೈಡನಿಂಗ್ ಅಂತ ತಿಳ್ಕೊಂಡು ಮೊದಲು ಮಾಡಿದ್ದದ. ಸೊ ಇದು ಅಕ್ವೈರ್ ಮಾಡೋದಕ್ಕೆ ಇದೇನ್ ಮ್ಯಾಪ್ ತಯಾರು ಮಾಡಿದ್ದದ, ಇದ್ರನ್ನ ಮ್ಯಾಪ್ ತಯಾರು ಮಾಡಿರೋದು, ಇದು ಎಲ್ಲಿ ರೋಡ್ ಹೋಗ್ತಾ ಇದೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ಬೇಕಾಗುತ್ತೆ ಅಂತ ತಿಳಿದಂತ ತೋರಿಸಿವಿ. ರೆಡ್ ಪೋರ್ಷನ್ ಅವ್ರ ಏನಂತಾರೆ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೋಡ್, ಸಮ್ ವರ್ಕ್ ಅದಾಗ್ಯದ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೋಡ್ ಅಂತ ತಿಳಿದಂತ ಹಂಗೆ ಹೇಳಕೈತಾರ. But the fact remains that, my lord, take it from my words. Some direction prakara or National Highway Authorities, ADLR discuss ಮಾಡಿದಂತ ಹೇಳಿದ್ರು. This both red portion as well as yellow portion is sought to be recommended for acquisition. Our color distinction eduk madra idu one existing road adantate. The point ಅವ್ರು ಏನ್ ಹೇಳ್ಬೇಕು, ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೋಡ್ ಇದು ಆಲ್ರೆಡಿ ಅಕ್ವೈರ್ಡ್ ಅದ, ನಮ್ಗೆ ಓನ್ಲಿ ಇಷ್ಟೇ ಬೇಕಾದಂತ ತಿಳಿದಂತ ಸಿಂಪಲ್ ಹೇಳ್ಬೋದಲ್ಲ ಅವರು. They are.
So as on date, according to you, as on date, the yellow portion which they are showing as the road is not a functional road. It is only a proposal for acquisition. That is your stand.
ಇಲ್ಲ functional ada. Functional ada.
Physically it is there.
Physical ada. ನಾನೇ ಹೇಳಕತ್ತೀನಿ.
Now, Mr. Kareddy, one more clarification. I've still not made up my mind. I'm just asking. So it's not that I've come to any conclusion.
Please, my lord, please.
Now, if we were to say that there can be deemed conversion except for this yellow portion, would it be okay? I'm just asking.
ಇಲ್ಲ, ಯಾಕಂತೇಳಿರಿ, ಈಗ ಅದು ಅಕ್ವೈರ್ ಆದದ್ದೇ ಇಲ್ಲ. ನಾನು ತಮ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಹೊತ್ನಾಗ ಮೊದಲು ಹೇಳಿದೆ, ಸಾಹೇಬ್ರೆ ನಾನು ಎನ್ಎಕ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಏನು ಮ್ಯಾಪ್ ನಲ್ಲಿ ಇರ್ತೈತೆ ಅದ್ರ ಪ್ರಕಾರನೇ ನಾನು ಹಾಕ್ಬೇಕಾ, ನನಗೇನ್ ಪೋರ್ಷನ್ ಬೇಕು ಎನ್ಎ ಬೇಕಂತ ತಿಳಿದಂತೇಳಿ ಅದ್ರ ಪ್ರಕಾರ ನಾನು ಮಾಡಿ ಹಾಕಿನಿ. ಇದು ಅಕ್ವೈರ್ನೂ ಆಗಿಲ್ಲ, ಏನಿಲ್ಲ. ಸೊ ಮೈ ಸಬ್ಮಿಷನ್ ವುಡ್ ಬಿ, ಮೈ ಲಾರ್ಡ್, without going into the details of this thing, my lords may kindly visualize this dimension of it so that we may have a little bit clarity. Now the question is whether this NA order deemed conversion ant madiddu proper ada illa as per law ant tavu madbitre ಏನ್ರಿ. ಈಗ ಆ ಎನ್ಎ ಆರ್ಡರ್ ಆಗತ್ತೆ ಅಂತ ತಿಳಿರಿ ಸರ್. ಎನ್ಎ ಆರ್ಡರ್ ಆದ್ರಾಗ ಎನ್ಎ ಆರ್ಡರ್ ಅಂತ ಆಯ್ತಾ, ಸಪೋಸಿಂಗ್ ಅದು ರೋಡೇ ಇತ್ತಂತ ತಿಳ್ಕೊಳಮ್ಮ. ಲೆಟ್ ಅಸ್ ಅಸ್ಯೂಮ್ ಆಸ್ ಪರ್ ದ ಅಥಾರಿಟೀಸ್ ಅದ್ರ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೋಡ್ ಅದ, ಅವ್ರು ಅಕ್ವೈರ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಪ್ರಶ್ನೆನೇ ಬರಲ್ಲ. ಮಾಡಿದ್ದಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಕ್ಲೇಮ್ ಮಾಡ್ತೀನಿ ಕಾಂಪನ್ಸೇಷನ್. ಅದ್ರದ್ದು ನಾವು ಇದ್ರಾಗ ಎಂಟರ್ ಆದಿವಪ್ಪ ಅಂತ ತಿಳಿದಂದ್ರೆ ಡಿಸಿಷನ್ ಮೇಕಿಂಗ್ ಪ್ರೊಸೆಸಿಂಗ್ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಗಬಹುದು ಏನೋ ಅಂತ ನನ್ನ ಒಂದು ಅಂಬಲ್ submission, my lord. Because the scope of the petition is whether under section 95A there is a deemed conversion or not is the scope.
No.
With due respect, the appellants are dragging this matter beyond that scope by saying the things which are not on record.
No, one submission.
He has to satisfy that definition of the that is 95. He has to show that is the actual position of the land.
No,
That's
just
what-
1 minute. Just 1 minute.
Please.
Just 1 minute. Just 1 minute. Now, the state has argued by relying on the term occupant. So
Yes.
one of the contention raised by them, they have also relied on some judgment to say that suppose you are not in occupation, you cannot claim conversion for that. Is one of the arguments raised.
Yes.
So now, no doubt, the government has not notified that portion, though in fact it is being used as a road. Now, if it is their contention that you are not an occupant of that portion, what do you say regarding that contention?
ಅಲ್ಲಲ್ಲ, ಆ ಆಕ್ಯುಪೆಂಟ್ ಅದು ಇನ್ ಡಿಫರೆಂಟ್ ಕಂಟೆಸ್ಟ್ ಬಂದದ. ಆಕ್ಯುಪೆಂಟ್ ಅನ್ನೋದು ಡಿಫರೆಂಟ್ ಕಂಟೆಸ್ಟ್ ನಾಗ ಬಂದದ್ದು ಅದು. ಈಗ ಸಾಹೇಬ್ ನಾನು ಅನ್ನೋದೇನಂದ್ರ ಈಗ ಒಂದ್ ಲೆಟ್ ಅಸ್ ವ್ಯೂಡ್ ಫ್ರಮ್ ಅನದರ್ ಡೈಮೆನ್ಷನ್. ಓಕೆ, ಈಗ ತಾವು ಡೀಮ್ಡ್ ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಮಾಡ್ತೀರ ಅಂತ ಹೇಳಿರಿ, DC ಆರ್ಡರ್ ಮಾಡ್ತಾನ ಅಂತ ಹೇಳಿರಿ. ಈಗ ನೌ ದ ಕ್ವಶನ್ ವುಡ್ ಬಿ, ಲೆಟ್ ಅಸ್ ಅಸ್ಯೂಮ್ ದಟ್ ದೇರ್ ಇಸ್ ಎ ಡೀಮ್ಡ್ ಕನ್ವರ್ಷನ್. ಈಗ ನಾನು ಅದನ್ನ ಉಪಯೋಗಿಸ್ತೀನ, ಒಂದ್ ಮಾತು ಉಪಯೋಗಿಸಿದ್ರೆ ನನಗೆ ಅಥಾರಿಟಿ ಬೇಕಾ? ನನಗೆ ಅಥಾರಿಟಿ ಇಲ್ಲ ಅಂತ ತಿಳಿದಂದ್ರೆ ದೋಸ್ ಅಥಾರಿಟೀಸ್ ಕ್ಯಾನ್ ಪ್ರಿವೆಂಟ್ ಮೀ. ಹೌ ದಟ್ ಇಮ್ಯಾಜಿನ್ಡ್ ಸಿಚುವೇಶನ್ will come in the decision making of this writ petition? The same contention. ಈಗ ನನಗೆ ಆ ರೋಡ್ ಮೇಲೆ ಸಪೋಸ್ ಅಧಿಕಾರ ಇಲ್ಲ ಅಂತ ತಿಳಿರಿ ಸಾಹೇಬ್ರೆ, ಇವ್ರು ಏನೇ ಮಾಡಿದ್ರ ಅಂತ ತಿಳಿರಿ. ಈಗ ಡೀಮ್ಡ್ ಕನ್ವರ್ಷನ್ ಆಯ್ತಂದ್ರೆ ಅವ್ರ ಪ್ರಕಾರ ಇನ್ಕ್ಲೂಡಿಂಗ್ ರೋಡ್ ಪೋರ್ಷನ್ ಡೀಮ್ಡ್ ಕನ್ವರ್ಷನ್ ಆಗುತ್ತೆ ಅಂತ ತಿಳ್ಕೊಳಮ್ಮ ಅಂತ ತಿಳಿರಿ. ರೋಡ್ ಅಂದ್ರೆ ಏನೇನ ಆ ರೋಡ್ ಇತ್ತಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಏನೇ ಇದ್ದಂಗೆ ಆಗುತ್ತಾ? ಹೌ that order of deemed conversion will change the nature of the things? One thing. Now the next question arises, whether state can claim the ownership of the road or I can still claim the ownership on the road. That is a different dimension and different issue that will be decided at an appropriate stage.
No, there's one point, I'll tell you why. I was just still thinking. Now you go to section 95 subclause 2 Roman 3. Just 1 minute. I'll just get the barrack. Mobile and open the mobile and net.
Regarding deemed conversion ಬಗ್ಗೆ ಸಾಹೇಬ್ರೆ,
section 95 subclause 2 Roman 3. Good. $95 2 capital A Roman 3.
Please me.
So what it says is may regularize or refuse to regularize except where such land, Roman 3, coming in the way of existing or proposed roads inner or outer ring roads, national highway, bypass over ring road, etc. So that is the power to reject video. That is the power they could reject if that place where you are seeking conversion of deemed conversion or conversion coming in the way of existing or proposed road, inner or outer ring road, national highway, etc. So I was just thinking what I had in mind.
No, it is a very healthy academic discussion. Kindly turn to Annexure C of the writ petition. Writ appeal 150 papers are there with my lords.
Yes, yes.
Is 33 gina agboden notes. 33 gina.
That is a revenue sketch.
Yes.
Revenue sketch.
ಈಗ ಸಾಬ್ರೆ ಇಲ್ಲಿ ತಾವು ಈಗ ವಿಚಾರ ರೆವೆನ್ಯೂ ಸ್ಕೆಚ್ ಇದು ರಿಕಾರ್ಡ್ಸ್ ನಾಗ ಅದ ಈಗ ಅಥಾರಿಟೀಸ್ ರಿಕಾರ್ಡ್ಸ್ ನಾಗ ಇದು ಬಿಟ್ಟು ಬೇರೆ ಯಾವುದಿಲ್ಲ. ನಾನು ಎನ್ಐ ನಾನು 1155/1 ಗೆ ನಾ ಎನ್ಐಗೆ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕಾದ್ರೆ ಇದನ್ನ ಬಿಟ್ಟು ನಾನು ಹೆಂಗ್ ಅಪ್ಲೈ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಈಗ ಇಲ್ಲಿ ರಸ್ತೆ ಅಂತ ಅದ ನೋಡಿ ಸಾಹೇಬ್ರೆ, ರಸ್ತೆ ಅಂತ ಈಗ ಅಲ್ಲೇ ನಾವು ಅದು ಹೇಳಿದ್ನಲ್ಲ ನಾನು ಇನ್ನೊಂದು ರಸ್ತೆ ಅಂತ, ಆ ರಸ್ತೆ ಇದೇನು ಇವರು ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೋಡ್ ಮತ್ತೊಂದು ಅದು ಅಂತ ಹೇಳಿದಂತಾರಲ್ಲ, ಇಟ್ ಈಸ್ ನಾಟ್ ದೇರ್. ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್ ಮೈ ಪೊಸಿಷನ್ ಆಲ್ಸೋ.
In the rejection order, my lord, we stated that it is not matched. That
First of all, reason. My lord, rejection order is not an order which is non-est in the eyes of law since it is after 120 days.
It has to be matched. The sketch has to be matched, my lord.
Your authorities in arbitrariness ಮಾಡ್ಕೊಂತ ಹೋದ್ರೆ
now Basireddy,
please,
I have a question for you. Please. Now let us assume hypothetically that we give deemed conversion for what he has sought for. Now, in so far as your proposal for acquisition, it is pending, it may come through today or tomorrow, it may come through. Now, if your proposal comes through, you are entitled to acquire for the yellow portion which is shown. Now, that will take care of your interest.
That's all.
That will definitely, lordship, that is there. But existing road, that is the lordship is read that provision. It is very clear. If any he is admitting that national highway is there, and he is
no.
No, the only contention.
No, I'm not admitting.
The contention of Basuraj Reddy appears to be that in spite of the fact that actually they will be using it as a road, in law there is no recognition of a road running through his property. His contention in law. Actually, according to him, he may agree with you that there is a road passing, but he's saying in the eye of law, since there is nothing to show in the record, since it is not acquired, that there is a road. So you give me conversion for the whole extent. That would of course be subject to the law of eminent domain. Tomorrow when you acquire, you will do it. Is what he's saying. Maybe we can at the most, we can ask him that he will not interfere with the de facto road. Though even if there is an order in his favor, we may ask him to file an affidavit. I'm just throwing it out that he will not interfere with the de facto road till acquisition is there, and he reserves his right to, in the event of acquisition, with respect to prior to 4-1, to claim damages, and after 4-1 entitled for compensation, but he may not obstruct actual movement of traffic. Maybe we can ask him, and is what I'm thinking, because his contention is in the eye of law there is no road, so I'm entitled for full conversion. Now suppose it was proposed for acquire, it was acquired, or there was something, then you could disqualify me from asking for the entire extent. But as on date it's not acquired, it remains my land. Even if traffic is running in my land, let me be given the benefit is what is appears to be his stand.
No, that is correct, my lord. No, my lord, that is not I read the definition, my lord. He must be occupant. He must be occupant, then only he seek for the acquisition, conversion. But admittedly, my lord, he is not in occupation of that portion.
No, correct. So the answer for that, I'm just putting myself in his place, will be legally, he is still the owner of that land and anybody using it are being permitted, and that he continues to be the legal owner of that land. So you can't take me outside the definition of occupant unless legally I have been deprived of that right of being an occupant of that land, either by acquisition or otherwise.
That my lord, regarding that portion, my lord, I seek some more time to make the submission regarding this, and any judgments are there, my lord, regarding this. Already established any road and all, my lord, that has to be, my lord, exclude, then only conversion must be there. There is a, I learned that, my lord, some of the judgments are there of its court regarding this, my lord, which is lordship is read, that provision, my lord. Even Malad, if he is a legal owner or not, if he permitted to the public to use that rod, he is not in occupation of that rod. So he cannot seek for the only advantage of that man getting more compensation. And I am also instructed that Malad, which is the road is there, Malad, already that is utilized by him, and he put up the huge construction on that road.
Which road?
Is there.
Which road? Which road?
Existing road, my lord, which was shown in the map, my lord, that grammar raste. He put up the huge construction.
No, that no. If that is so, then you either exchange it or you can.
Yes, that one, my lord. That's all, my lord. I have made the submission regarding that one, my lord. Will take action against him regarding the, my lord, how to, my lord, disposition those that and all. No, my lord, your auspice suggested, my lord, whatever land is going to be acquired, then which one land is already utilized by him, you deduct that portion and give the compensation. That one will your auspice directed us to make this one also. Because now that road is already used by him, we are not using that road. That portion has to be deducted in the future acquisition.
That we'll see. Insofar the village road, it's beyond the scope. The only point now remains that you have not acquired it. So that what next time you make submission and review, let us see, I'll hear you on that. Now their contention is simple, that it's not acquired. If it's not acquired, I'm legally the owner. If I'm legally the owner, even if somebody is using, including traffic, you cannot say I'm not an occupant, because legally it's still under my control. At the most, they're using with my permission, which I have allowed, is his contention. On that, what do you have to say? And whether under 95(2), is there any right for you to say that since it's a proposed road? So where is it a proposed road? It's not notified. Suppose master plan, you say, if it's shown, that's a different matter. But there's no material to show that as on date, this area which you have shown in yellow has been proposed for a national highway is nowhere forthcoming from the material on record.
But he
even as on today also, they have not yet sent for proposal for acquisition.
No, it is there. Page number 42 in my additional documents, my lord. It is there.
Yeah, adu bare acquisition.
No, your name is also there, my lord. That is that portion also there.
No, my lord, with due respect, the other side is unnecessarily dragging and unnecessarily saying, if that is there, why you are saying that?
He filed the writ petition, my lord, directing the authorities to acquire the land, because that road is already used by the public. He only filed the affidavit, the writ petition before the court.
Court video, please.
Directed us to make the survey.
Court video, please.
Video.
ಈಗ ಬಂತ್ ಸಾಹೇಬ್ರೆ ಇವ್ರಿಗೆ ನನ್ ವಿತ್ ಡ್ಯೂ ರೆಸ್ಪೆಕ್ಟ್ ನೀವು ಅವ್ರಿಗೆ ಕೇಳ್ಕೊಂತ ಹೋದ್ರೆ ಎಲ್ಲೆಲ್ಲಿ ತನ ನಮ್ಮ ರಾಯಚೂರಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಬಿಡ್ತಾರ ಅವರು. ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಬಿಟ್ಟು ನಮ್ಮನ್ನ ಎಲ್ಲಾರನು ಅಲ್ಲಿ ಬಂದು ನೋಡ್ ಬರ್ರಿ ಅಂತ ತಿಳಿದಂತಾರೆ ಇವರು. ಕೋರ್ಟ್ ಆಫ್ ಲಾ.
This is the order of the
argument has to be legally.
21, my lord. in the read petition number 226404 of 2020. That is, I produced along with the additional document. That is page number 20, my lord. Annexure N number. He only filed Yankanda Yadav against the government. But prayer is kindly seen, my lord. Prayer to compensation. The mandamus directing the respondent to complete the acquisition proceeding by paying the compensation to the land acquired of the subject belonging to the petitioner. Survey number 11555, 1156, 1174, 1167. These are all the numbers. He only filed the petition.
No, correct. But now we are concerned about 1155/1 and 1155/2.
Yes, sir. Yes,
So what he's saying is, until you acquire, you can't say I'm not an occupant of the land.
But that is the, my lord, your lordship is referred that one, my lord. If any national highway or whatever it may be, it is acquired or not acquired, that has to be portion has to be left. But now we are ready to leave this portion. We are ready to, my lord, if we made the application, definitely we'll convert the land immediately without
concession
and also, my lord, without insisting any documents from him.
ಏನು ಬೇಕಿಲ್ಲ ನಿಮ್ದು ಏನಾದ ಕಾನೂನು ಪ್ರಕಾರ ಅದರ ಪ್ರಕಾರ.
Let us see. Now you want to make any other submission.
Some more time, my lord.
ಅವ್ರು ಹಂಗೆ ಅಂತಾರೆ ಸಾಹೇಬ್ರೆ, ಬೇಕಿದ್ರೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಕೇಳ್ರಿ ಅಕ್ವಿಸಿಷನ್ ಕಳಿಸ್ಯಾರ.
Also, my lord, the notification which is already issued and what is the, my lord, further development has happened, that will lordship bring to lordship notice. Even that affairs court judgment also regarding, my lord, utilize the national highway, state highway, that has to be given, that has to be except that one authority can proceed about the acquisition, the conversion.
Let us see. We'll have it. On
audio, please. Audio, video, please.
next Friday at 5 o'clock. We'll conclude it on that day.
Please, my lord, please.
Yes. Mr. Kareddy, please have a look at that
95A subclass.
2A. Just have a look at it.
My lord, with due respect, my lord, the scope of the.
Let us see.
Please, my lord. Please, my lord. Kindly strike balance, my lord, between. I don't. ನಾನೇನು ಸರ್ಕಾರದ ಗ್ರಾಬ್ ಮಾಡಿ ನಾನು ತಗೋಬೇಕಂತ ಏನಿಲ್ಲ. ನಾನೇನು ಯಾರ್ದನ್ನ ಪ್ರಾಪರ್ಟಿ ತಗೊಳ್ಳೋದಕ್ಕೆ ಕೇಳಕೈತಿನ. ಇವ್ರು ಹೆಂಗಿದ್ರು ಅಕ್ವೈರ್ ಮಾಡೋದ. ಓನ್ಲಿ ಡಿಫರೆನ್ಸ್ ವುಡ್ ಬಿ ಈಗ ಏನೇ ಆಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರ ಅಕ್ವಿಸಿಷನ್ ನನಗೆ ಏನೇ ರೇಟ್ ಬರ್ತದೆ ಫಾರ್ ವಿಚ್ ಐ ಆಮ್ ಎಂಟೈಟಲ್ಡ್.
No, I'll just tell you one point. Now, what he must be thinking, he may be thinking, suppose order is passed, and then you come and sit on the road. What will happen?
ಬೇಕಿದ್ರೆ ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ತೀನಿ.
That I want to know. I want to know that.
ಅಲ್ಲ,
yes. Then, just 1 minute. Then that will serve your purpose, Basreddy. Now, just look at it like this. Now, in that sketch, whatever is the yellow portion, you have demarcated G, I, J, whatever.
Please.
I will ask him to file an affidavit that in the event the court comes to the conclusion that there is conversion and conversion is granted. Since still the land belongs to me and it has not been acquired, I will not obstruct the current usage in A, B, C, D, E, F. I will ask him to file an affidavit. There ends the matter. Then you go on and you take your time to acquire it.
One more, my lord. He has to hand over the portion which is already acquired by him.
That's a different matter. That we can't enter into.
That is the problem.
That we can't. How can we enter into that now? That is up to you.
That is his portion only, my lord.
That is beyond the scope of the present inquiry. At the most, I'll ask him to file an affidavit that will take care of your interest. If that is so, then if we were to pass an order for the deemed upholding the order of deemed conversion, subject to this rider.
I will not interfere. I will not obstruct till the land is acquired within a reasonable time.
Well, we already issued the notification.
No, so then Mr. Basareddy, you keep an affidavit ready. You keep an
Myself,
affidavit. Yes, keep
Please.
an affidavit ready to be filed on the next date. Now, Basareddy, this would be the one option. Too much, if you ask your officials, they will also not be in a position to say. But your interests will be taken care of insofar as the factual aspect. You think about it. Anything in law you want to make, you make submission. But this is what we have in mind, which appears to be an equitable.
Sir, I walk an extra mile. ಏನಂದ್ರೆ ಈಗ ಅವ್ರೇನ್ ವೈಡನಿಂಗ್ ಮಾಡ್ಬೇಕಾಗ್ಯದ ಅಕ್ವೈರ್ ಮಾಡ್ಬೇಕಲ್ಲ ಈಗ ಇದ್ರ ಜೊತೆಗೂ ಪಕ್ಕಕ್ಕೆ ಮಾಡೋದಿರತ್ತೆ ಇದು ಎಲ್ಲಾ ವರ್ಕ್ ನಿಂತು ಹೋಗ್ಯದ ಏನ್ರಿ ಅವ್ರ ಅಕ್ವಿಸಿಷನ್ ಪ್ರಪೋಸಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ವಿತೌಟ್ ಟಿಲ್ ವೇಟಿಂಗ್ ದ ಅಕ್ವಿಸಿಷನ್ ನಾನು ಬೇಕಿದ್ರೆ ಅವ್ರಿಗೆ ಮಾಡ್ಕೊಳ್ಳಂತ ಹೇಳ್ತೀನಿ ಟೈಮ್ ಹಂಗಂತೇಳಿ ನಾವು ಅಫಿಡೇವಿಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಇದು ಮಾಡಿದ್ಮೇಲೆ ಅವ್ರು ಅಕ್ವೈರ್ ಮಾಡ್ಲಾರ್ದು ಮತ್ತೆ ಪಜಿಟಿವ್ ಬೀಳಬಾರ್ದು ಇವ್ರು ಇಂಥ ಅಫಿಷಿಯಲ್ಸ್ ಇರ್ತಾರೆ
already developed, already developed.
Correct. Developed in whose land?
Paper
Now you can't get into that. As of now, it's not acquired. Now let him file an affidavit. We'll consider it. You think about it and you come back on next Friday. You keep that affidavit ready.
5 o'clock, my lord.
Yes, 5 o'clock. 5 o'clock. Because there's a bench.
My lord, may I make one submission?
Just 1 minute. Just 1 minute. This is the matter for further hearing on next Friday at 5 o'clock. Yes.
Yes, my lord. Serial number 6, lordship, pronouncement of judgment at Kalburgi bench.
No, the calculation that was given, was it with the consent of the other side only? We wanted to know.
No, my lord. It has already been discussed in the year 2021 itself.
No. We wanted to know one calculation was given, isn't it?
Yes, my lord.
That calculation is after sharing it with the other side, isn't it?
Yes, my lord.
That's all. We'll pronounce it.
No, my lord. It is already disposed of. The mistakenly 201387 about 2021 in long back 2021 itself is disposed of in the Lok Adalat, my lord. The insurance company has deposited.
Please check. Entry was.
Mostly the number wrongly ಇದು ಆಗಿರ್ಬೇಕು my lord, because 18/12/2021 ನಲ್ಲಿ Lok Adalat dispose ಆಗಿ they have deposited the amount and claimants have withdrawn the amount also.
Okay, we'll check it. Okay, we'll check it.
I think it is 22, my lord. I searched in the.
Okay. Yes.
Court officer, sir. Sir. Court officer, sir.
Court officer, sir.